Welcome everyone to our celebration of Human Rights Day and the official launch of Time for Reparations, A Global Perspective, edited by Professors Jacqueline Baba, Margarita Matake, and Caroline Elkins. My name is Natalia Linos, and I am the acting director of the FXB Center for Health and Human Rights at Harvard, and a social epidemiologist who has worked both in the United States on structural racism and health, and previously for over a decade at the United Nations on inequality, health, and human development. As many of you know, Human Rights Day is observed every year on the 10th of December to commemorate the day the UN General Assembly adopted the Universal Declaration of Human Rights. The theme for this year is equality, reducing inequalities, advancing human rights. Oftentimes in public health, as well as in many other fields, we spend tremendous energy and effort in documenting and describing injustice, bearing witness to discrimination, violence, and atrocity, reporting on stark health statistics that show the cumulative impact of historic and ongoing injustice that results in lives cut short. This is critical. Yet often it leaves people asking, so what do we do about it? This is why today's discussion on reparations, on a Human Rights Day focused on reducing inequalities and advancing human rights, is so timely and so critical. We will hear today from an illustrious group of authors from around the world who have engaged in rigorous thinking and advocacy around how we move from the darkest and most inhumane moments in our society to acknowledging atrocities and taking action to redress and repair, and in that way, build the foundation for a more equitable future. At the FXB Center, this work on reparations is not new and is grounded in years of work, especially from Professor Margarita Matake, who directs our Roma program, to link history and ongoing injustice, to show how discrimination shapes opportunities and inequities across multiple sectors, from education to health, must be addressed. I'm also very proud that with the support of the Robert Wood Johnson Foundation, the FXB Center has just recently begun a new large initiative specifically on reparations for people of African descent in the United States to bring more of the medical and public health community, who to date have been largely absent for these discussions, into this conversation around how do we repair, atone, and build a better future. Our hope is to make the public health case for reparations, showing how different frameworks or models could help eliminate the stark and ongoing health inequities that we see between Black and white Americans, and which have been so much in the news these days because of COVID. And using quantitative models help policymakers make decisions that are important for them. But let me turn back to this book launch and our launch today to thank the people who do the behind the scenes work to make events like this successful. First of all, Veronica Lewin, our Director of Communications and Public Affairs, and Megan Daly, our communications managers, and of course, the editors of this book for bringing you all together, and the many authors who are spending hours with us this morning to have this conversation. And it's my honor to introduce and pass the floor to Jacqueline Baba, who likely does not need much of an introduction, but I will provide it anyways. Jacqueline Baba is a professor of the practice of health and human rights at the Harvard T.H. Chan School of Public Health, the Jeremiah Smith Junior Lecturer in Law at Harvard Law School, and an adjunct lecturer in public policy at the Harvard Kennedy School. She's also our director of research at the FXB Center. She received a first-class honors degree and an MS from Oxford University and a JD from the College of Law in London. Professor Baba, the floor is yours.
Thank you so much, Dr. Linos, and thank you to Veronica Lewin, as you rightly said, for making all this possible with Megan, and to all of you colleagues and friends and our audience for joining us today. Insofar as this book has a birthplace, it's Boston. All three editors live in Boston. The conference that laid the seeds for the initial book took place in Boston. And the Harvard FXB Center for Health and Human Rights has provided a gracious and generous institutional home for our book project, and it is also in Boston. Boston is also home to some of the very best hospitals and universities in the world, and has been for decades. And yet, not everyone who lives in Boston has access to high quality medical care or education and the benefits that flow from these. Even more stark, not everyone who lives in Boston has anything approaching the same life expectancy or wealth. Data from the state of Massachusetts disparities in health studies show dramatic differences today between the health status of white and Black Massachusetts residents across the age spectrum. For example, between 2005 and 2008, the most recent data I could get hold of, deaths from prostate cancer amounted to about 42 per 100,000 for Black adults, 42 per 100,000 for Black adults, but only 22 approximately per 100,000 for white adults. So white men in Massachusetts had close to half the mortality rate for prostate cancer compared to their Black counterparts. Infant mortality rates are even more disparate. 10.69, in fact, infant deaths per 100 live births for Black babies, compared to 4 per 1,000 live deaths for white babies. So an enormously stark difference. And wealth differentials, wealth, of course, to some extent a product of generational assets, but also of access to education, of access to the types of institutions that we see so well represented in Boston. Wealth differentials are even more stark. According to a 2015 study, white households in Boston had a median wealth of $247,599, so $248,000, and Black households had a median wealth of $8. These dramatic disparities in one of the wealthiest democratic-leaning states in the US are evidence of the ongoing, pervasive, and devastating impact of the failure to institute reparations for enslavement on contemporary African Americans. And this failure constitutes a preventable health risk, an enduring driver of wealth deprivation, a comprehensive justice failure that is mediated on a daily basis by the many intersecting factors that contribute to what we now commonly refer to as American structural racism. Time for Reparations, the book that we are delighted to be launching today, does not have a chapter about Boston, though of course it could, but it has chapters that consider the enduring impact of enslavement in other parts of America and in other continents, including, as you'll hear, in Europe. Our book does not, however, just limit itself to a consideration of the imperative of reparations for enslavement. Our authors also explore the enduring impacts of unrepaired colonization, impacts that range from dramatic material impoverishment and wealth theft affecting formerly colonized populations, to continuing abusive appropriation of cultural and historical assets. You will hear about these legacies of injustice in countries with very different histories, including Guatemala, Guadeloupe, Algeria, Indonesia, and Jamaica. And while enslavement and colonization constitute the most pervasive and the longest lasting state-sponsored injustices, our book includes chapters that address the imperative of seeking reparations for other atrocities too. These include genocidal violence, pervasive use of torture, enforced starvation, forced sterilization, and other grave human rights violations used to dominate oppressed populations, including populations still subject to occupation today. One of the goals of Time for Reparations is to make the case for the urgency of instituting reparations through a wide spectrum of strategies. Monetary reparations, while essential, are by no means the only tool available. Truth-telling, including historical revision, apologies, are non-negotiable starting points for repairing past harms, we argue. Memorialization, school curriculum reform, interrogation of the role and place of national monuments, structural economic and political reforms, and implementation of carefully monitored non-discrimination practices are others. And so over the course of the next sessions, part of our discussion, you will hear commentary about each of these reparatory strategies, the challenges that arise in securing them, the obstacles that undercut effective implementation, and the political forces rallied to discredit the very legitimacy of the demand for reparations. Our hope in launching this book on Human Rights Day 2021 is to contribute to a growing movement that is insisting on placing the demand for reparations for past state-sponsored harms center stage politically, out of the shadows of oblivion or irrelevance. When we started working on this book several years ago, many of our friends and colleagues thought we were at best naive to think that reparations could be an issue with any realistic prospect of serious political traction. When we started working on the book, no mainstream politician included the demand for reparations in his or her agenda. But as we launch our book today, from France to California, from Belgium to India, the call for reparations can be heard. So let us examine the issues a little bit more closely. We start this launch with an inquiry by panel one into the historical legacies that endure from past injustice. And you'll hear from colleagues who work on that historical legacy. We then move to a second panel on reparations in practice, an examination of the social and political impact of reparatory measures that have already been instituted, their successes and their failures or their limitations. And our third panel turns to the future, to outstanding claims and the role of reparations in tackling unaddressed forms of social injustice. And finally, we'll hear from a legendary African human rights hero whose seminal contributions shaped one of the most significant reparatory exercises of our time. Albie Sachs, you'll join us at the end of our event. So it's now my great pleasure to introduce my fellow editor, chapter author, and Pulitzer Prize winner, Professor Caroline Elkins. Professor Elkins is a historian of Africa and of British colonization and a faculty member at Harvard. Her graduate research into the torture of Kenyans by British imperial forces in the 20th century provided crucial evidence for successful reparation claims by several elderly Kenyan torture survivors in the British courts, a first of its kind. And her chapter in our book describes that journey. So I'm delighted to hand over to Professor Elkins to chair our first panel. Over to you, Carrie.
Thank you so much, Jackie, and thank you for that incredibly generous introduction, as well as your rich and again, deeply nuanced points that you made in the introduction to our session today. It's with great pleasure that I chair this panel, and I would like to direct my remarks briefly just to the panelists as well as to all of the contributors, and to express my gratitude for your incredible work, for the richness and nuance of your essays that pushed me myself to think more deeply and richly about my own work, my research and writing, and equally as importantly, the ways in which your chapters have been brought into my own teaching. And in fact, Professor Baba and I teach a course together for several years on human rights in the Global South. And I can say with great pleasure and also with great humility, the degree to which your thinking and writing and cutting edge research has made its way into our classroom, to our students, galvanizing them in the ways in which they think about they themselves can at one point put themselves in your shoes and affect change on a global scale. So I thank you for that. I also express my gratitude to Jackie and Magda for just what has been a wonderful collaborative experience. So without further ado, turning to this panel on historical legacies that endure because of historical injustice, we have three wonderful panelists, Michael Fischbach, Mariel Fanel Mendez, and Nicole Imler, each of whom are going to have about 5 to 7 minutes to address a question that I posed to them, and which has been posed within the context of our agenda, which is, what is the enduring impact of historical injustice? And I must confess, having reread again your chapters last night, I was reminded the ways in which some of the themes intersect, but also the ways in which these broader continuities are also challenged when we think about the particularity of historical context. And I think as speaking as somebody who wears the historian's hat, this question about continuity, this question about broader themes, at the same time balance between the particularity of local communities, the particularity of historical context, the particularity of time and space. So without further ado, I will turn first in order of appearance to Michael Fischbach. We will then turn to Mariel Fanon Mendez, and then finally to Nicole Imler. I would encourage panelists, if they have any thoughts, questions as we're going on, to please put them into the chat. I will be delighted after we finish up with some initial opening remarks, to begin what will be a lively conversation and also invite panelists to respond to each other. So I will turn now to Michael. If I would encourage us all, if we could stick to our 5 to 7 minutes, so we therefore have some time for discussion. So Michael, I shall turn to you.
Thanks so much, Carrie. Appreciate it. And I'm really honored to be here on this day, Human Rights Day, and celebrating the launch of this very important book. The long-term historical legacies of injustices on the level and scale and in the places that are discussed in this book. In looking at the part of the world I studied, what befell the Palestinian people and what they call the Nakba, 5 things come to mind very quickly. I think the first is that, in terms of historical legacies, is that still in the 20th century, we are seeing with our own eyes in real time the tragedy that I believe is inherent in ethnic conflict, where combatants, where winners and losers, when refugees, when victors are essentially defined in ethno-religious terms. And certainly the Nakba suffered by the Palestinians is a great example of that. When 80% of the Palestinian Arabs who had resided in what became the state of Israel after the 1948 war, 80% were gone, either driven out, expelled, fled from fear. But regardless of why they left, the new Israeli state in June of 1948 took a decision not to allow them back. And that's because they were Palestinian Arabs, and the new state of Israel was a self-defined Jewish state. So I think the first legacy I see in my studies of this part of the world has been the ongoing tragedy and challenge to the human consciousness in the 21st century. Is the notion of an ethnically or religiously identified state still something the human community wishes to uphold? Number 2, I think the historical legacy bespeaks the issue of erasure, of identity, of national identity, of cultural identity. When in the case I studied, when over 350 villages were physically destroyed, when land, localities, natural formations are renamed, a deliberate attempt to erase the existence of previous cultural and institutional legacies, not to mention human legacies, I think is one of the ongoing tragedies. Some Palestinians, quoting poetry, say that the land itself speaks Arabic, a constant cry to say that, you know, the villages may be gone, you may rename the streets, but the land itself has historic memory. The third thing that comes to my mind about the ongoing legacy historically of these kinds of tragedies that we've discussed in this book has been the massive transfer of wealth. In the case of the Palestinian refugees, somewhere at least on the order of $800 million, 1948 dollars in property was left behind, in landed property that was confiscated by the Israeli state. An unknown amount of movable property, automobiles, farm animals, factory stocks, personal property. It not only provided a massive windfall for the cash-strapped new Israeli state, but overnight, for an agriculturally oriented society, by depriving people of their land, to be refugees nearby in nearby countries without land is social and economic destitution on a massive scale. I think the fourth thing that comes to mind is the concept of refugees themselves. In our modern world, people tend to think of refugees as people fleeing who essentially are seeking resettlement elsewhere for a better life, fleeing from ethnic cleansing, discrimination. Palestinian refugees, on the other hand, overwhelmingly have insisted on their right to return to their homes. And the vast majority of them live within 100, 150 miles of their original homes. So I think the question of refugeehood and what we do with refugees is highlighted by the case study I studied. And certainly the question of empowering people, that refugees have a voice, they have rights, and should not simply be seen as pieces on a checkboard that global actors can move at will. Finally, I think the case study I looked at shows that the question of obliging state actors to carry out the reparations, to make historical statements of regret and apology is very much conditioned, unfortunately, on global balance of power. It's one thing when a country's been defeated at war to oblige it to compensate victims. When a country is victorious, when it has considerable international aid, the strictures on it to own up to its part in historical wrongs are greatly reduced. And so these are really, I think, the 5 things that I would point out to as long-lasting historical legacies based on the case study that I presented in this book.
Thank you so much, Michael. You can see me taking furious notes. And thank you for really laying out for us in 5 points, but also very nuanced points, some basis for discussion as we move forward. I will turn now to Mariella.
Okay, thank you.
Thank you.
I will try to answer to the question. First of all, if I may, I will say there is right now, there is two juridical procedure, one from Martinica and one from Guadeloupe. This Guadeloupe I work on in my chapter. And I mentioned Martinique because it's also another way the state is answering to a legitimate demand from Afro-descendants, and how they push their demand out of any juridical system. Because they used a law from 2001, it's a law called Law Taubira. It's a memorial law, what we say, because there is no any normative possibility to sue someone with this law. But they use it in a way they were saying this law, as we can't, as a descendant of enslaved people, as we can't sue the state and ask for its responsibility, this law is a law of inequality. And they try to force the state to review this law. And they were defeated, of course, first step, second step, and they went to European Court, and the court said, of course, there is some discrimination with this law because the system is not the same for all the peoples. But there was an appeal, and this appeal was in October 2021, and the state representative said, but the abolition and enslavement is ended since long time, and we cannot use that to open a file because there is a too long time and there is no more enslavement right now in our country. And it is exactly the same response we got in the case of Guadeloupe when we asked to the Constitutional Court to give its feedback on one article of the Abolition Act from 1848, saying preparing the amount of money could be given to the enslaved and owner or enslaved person, and of course we got exactly the same answer from the state. There is no reason to continue to ask for reparation, and we can make some memorial day or whatever, but in any case, we can make reparation for different reasons. And one of the reasons is because enslavement is absolutely end. But what it is interesting, after this argument with the Guadeloupean agricultures, one of the deputy of National Assembly, through a law called Citizenship and Equality, asked for the abrogation of this article. Abrogation of this article, asking precise, given some precise amount of money to the owner and slave. And it is exactly what we are. It's a kind of hypocrisy used by French government to delete in the law. It is an official law, and it is always on the website of the National Assembly. And it is presented as a human rights corpus, French human rights corpus. And in his French human rights corpus, there is this law referring, this Article 5 of the law of 1848, put again the new free in the situation to be considered as a furniture. And it's happened after what we did in Guadeloupe. It was in 2018. And in the two examples, Guadeloupe and Martinique, we got exactly the same answer. And there is no way to get, right now, there is no way to get reparation, to get reparation. But the consequences, the enduring impact for people of African descent, and particularly in the colonized country, in the colonized territories, as a Réunion, Guadeloupe, Guyana, or Martinique, is very well documented. And in my chapter, I mentioned the level of poverty and the level of poverty between France, what we could call metropolis, even I don't like this word, metropolis and the colonized territory. There is a huge difference of level of poverty, level of education, and level of health. And we have seen that during the pandemic. The management of the pandemic was totally different from the metropolis and the Guadeloupe, for example, on Martinique. It was absolutely not the same way to manage by the states manage this pandemic. And one of the effect of this pandemic, it's the decision taken. By example, we were in confinement, under confinement, but for the Guadeloupe and Martinique, they were under curfew, as it is a state of war. We did not have such decision taking in France, in France metropolis. We don't have this. And the number of deaths in Guadeloupe and Martinique was higher than in this island, in this territory, than in the metropolis, because the management was totally different, and they did not pay attention to the people. And the situation in Guadeloupe, for example, the hospital, the main hospital in Pointe-à-Pitre was burned 3 or 4 years ago, and it is still not rebuilt. That's why it's very complicated to manage properly the situation. And if you look at the situation of agriculture, the impact of chlordecone, for example, on the ground is very important. And it is forbidden in France, metropolis, but not in this colonized territory. And the level of education and the level of poverty is still there, and the level also of jobless is very high regarding the level in France, because as I mentioned, for example, for young people from 18 to 24, the rate of jobless is 66%. In France, is only 11%. It is, of course, we continue, but it's really difficult to continue to sue the state, the French state, and as a consequences for Guadeloupean agricultures, the owner of their land, because they rent the land to a descendant of owner of enslaved, Hubert de Jaham, and the consequence for them, this person decided to open some files against agriculture and to ask them and to try to get the expulsion of some of their agriculture. It is where we are, and we are completely harassed by this expulsion because we need to make some individual cases rather than to have a collective cases on reparation.
Excellent. Thank you, Marielle. And I think we'll probably come back to some of that in our broader discussion, many points that you've made, but certainly the questions about individual cases versus the collective, and that as sort of being a kind of both a potentially effective legal strategy. But I think it's a segue into now Nicole, who also raises questions around the cascading effects of that, both on particularly in local circumstances. So Nicole, I will now turn to you.
Thank you.
You're on mute, Nicole.
Oh, sorry. It's me.
Yeah, thank you very much for preparing so nicely the floor for my contribution. So yeah, the chapter was called Colonial History at Court, so legal decisions and their social dilemmas. And it deals actually with the question, what is the power of a civil court case in addressing this kind of colonial historical injustices? And to what extent is there the legal frame also, what has it to offer to deal with this legacy? And so my chapter showed actually on civil court cases here in the Netherlands, which happened now since 10 years, that on the one hand, these legal court cases really opened up a debate. So the power is to, to get into the public. But on the other hand, of course, there is some dilemmas connected to those legal cases. And just to be a bit specific here, so it's about mass violations, mass massacres in the decolonization war in Indonesia, where the Dutch military intervened in the independence struggle to keep their colony. And they, in this decolonization war, there was independence war, you might better say, a lot of massacres happened on Indonesian sides. And in 2009, Indonesian widows whose husbands have been killed by where a whole village was massacred, 9 widows and 1 male survivor stepped in front of the court and they claimed justice. And this today, we call them the widows from Brava Gede, because they have become the image of the colonial disaster, because they succeeded in court that the judge said the Dutch state has to take responsibility. And this for the first time, the status of limitation, which has fallen, because it was seen there were still witnesses, there were widows alive who made their testimony. And so they won the struggle, which was really a historical a historical case. But what happened next? So what we see now since 10 years, one court case follows the other. First, the widows claimed justice for their murdered husbands, then the children came and for their murdered father, then the broader family came, and then not just mass executions, but also torture and rape. So we see the last 10 years that the categories for which you can claim justice, they widen. But of course, you also see the unintended consequences, because those make claims who feel excluded in the first place. So while first only the widows received acknowledgement, the children felt excluded. And this felt exclusionist thus created social problems on local level. So there is a lot of struggles on local levels in order to, because it's felt as a collective injustice, whereas the legal provides only an individual way to, in the Netherlands, to say, you know, you bring individual proof, and then you you get individual recognition and individual compensation. And this doesn't match so much with the feeling, for example, in this village, that it's a collective experience they have. So you would need to have a kind of collective response to it, and then also give the local community a say how this instrument has to look at. And here we are then a little bit at the power hierarchies involved in legal instruments, that it's mostly, in this case, it's the Dutch who say, you know, how the repair has to look like. So it was not, so the idea now, it's apology and individual compensation, like 20,000 euro for individual victims like the widows. One might wonder, if you interview people in those local settings, what would their idea of justice be about? And I think if we talk about transitional justice, also in this book, there is now such an imagination about what justice should look like in the legal area and the political area. Whereas what I find in my anthropological work in interviews, that the notions of justice are much, much broader. For example, if we wouldn't say it's reparation, and then it's often very much associated, you know, with compensation, with the monetary. And the money is, of course, also an instrument which is used. It's the effect of using law that you end up with compensation. But if you use, like, for example, notions like social repair, then it's a much broader notion in kind of re-establishing relationships in communities. But also, and this is my case, is about, if you look at these court cases from, we think it's about the Dutch state and Indonesian victims. So it's about the former colonizer and the former colonized. But if you look who is actually the actor behind those court cases, it's the diaspora here in the Netherlands. They are the drivers of those actions. And then diaspora, you could say, they have their own suffering and their own, because they feel themselves still not acknowledged as equal citizenship, as equal citizens here in the Netherlands. So actually the court case is used as an instrument to speak in the name of the former victims, actually in order to get our own voice in the Netherlands. And I think this is well how the historical injustice and the present day injustice, here you see the continuities, if you also look who is actually behind those court cases. And I think this connects very nice to the earlier to say, you know, if you have a law which is about citizenship and equality, that would make a completely different debate. How do we look at this kind of court cases which are labeled addressing historical violence in Indonesia, while it's also about present day violence in a different way in the Netherlands. So I think this is what my contribution was, to shift a little bit. If we do interviews bringing more notions of justice to the fore, then we can better see also what is the power of a legal court case, but what are also the limitations, and the limitations triggering us to what extent do we need to broaden the debate. And yeah, I think I'll leave it with that.
Thank you so much, Nicole. And in many ways, as we were saying, your piece and your comments here reflect through the lens of the Netherlands and through the lens of this case on Indonesia, a problematizing of the question of the role of the courts, if you will, as a blunt instrument, and the cascading effects of that. And two things. One, I'd like to invite you each, if you'd like in any way, to respond to each other in some of the remarks, and perhaps throw out a query or two. And we also have a few coming in on the chat. But I am curious in these different scenarios, when we're thinking about enduring impact of historical injustices, the role of whether it's domestic or international courts, and I would add academics with our research, the kind of work that each of you have presented in parsing out and documenting complicated histories. In many ways, and this you gesture to in your piece, Nicole, and it's come up in others, perhaps a little less so, but the question about post-colonial states, and also trying to, and I certainly can speak in my own circumstance, the challenges of documenting for a court, and even in our own work, who did what to who. And so I'll sort of put that there, and also the question, and I think in some ways perhaps a little bit more directed to you, Marielle, but in general, the question about mechanisms within the legal system that allow for academics to introduce to the court their work in ways that, so for example, in the case in the High Court, it was really, this was a tort claim, right? It was a big personal injury case circumventing many of the roadblocks that you point out that has happened in the Martinique and Guadalupe case. And so I put that out as well in terms of the role that academics and legal practitioners play in working together to try to at least document within the courts and to have this on record, the impacts of historical injustice. So I will sort of pause there and allow, if you wish, to invite you to respond to any of those questions that I raised, or anything that might have come up in each other's remarks. And so, Michael, you have been patient. I will turn back to you. Yes.
Thanks. I would just say that I won't say it's unique, but the case of the Palestinian refugees is in fact a highly documented situation. I worked a great deal on property losses that were sustained, both land that was left behind, as well as other types of property, bank accounts, and things like that. The United Nations Conciliation Commission for Palestine, UNCCP in particular, documented to the extent that it could, based on British land records, every single piece of Arab-owned property within the boundaries of what became Israel in 1948. These records indicate substantial losses, like I said, value, although the UN never admitted publicly, but the value at the time they estimated of $800 million US just in land alone. And these records sit in the UN Secretariat archives under literal lock and key in New York City to this very day. We also have records from another UN agency, the UN Relief and Works Agency for Palestine refugees in the Near East, UNRWA, on exactly who is a refugee. We have Israeli government agencies, the land registries, the Jewish National Fund. We actually, in the case of Palestinian refugees, know a great deal about who they are, where they are, and what losses they sustain just in terms of property. So here's a case study where actually the issue of who are the victims, who took what from whom, is fairly well known. Why nothing's been done 3/4 of a century later, of course, is another issue we can get into. But academics and others actually, in my case, have a very rich set of sources on which to base claims for things like property compensation. There have been formulas come up with by a number of different organizations about things like the value of moral reparations and so forth. So there are some ongoing tragedies where the question of who did what to whom and how much was it is actually pretty well known, despite the inaction in making those kinds of reparations real.
Thank you for that, Michael. And I have to say that your field, some of your work and others, I had some graduate students, Srimati Mita, who's worked on banking, tracing some of these records, has served as a model for many historians on how to forensically document the kind of evidence that we need for other historical injustices. So Marielle, I will turn to you.
Even to speak. Oh, sorry. I'm sorry. Is it okay? Hello? I lost you.
We can hear you.
Is it okay?
Yes.
Okay. Sorry. In France, there is some difficulty to speak and to work on reparation. First of all, because even at the low level, all the people agree there is no reason to get reparation, as I mentioned before, as this history is now ended, whatever the consequences for people of African descent in different territory. And they prefer to have a remembrance or something, memories, or but not to talk about. And one of our difficulty is what we are doing in Guadeloupe is not only about law, it's also about politics, because to work, what we want is to get the restitution of lands, because all these lands were stolen by the colonizer. And it is what we have decided to work on this first demand to the Constitutional Court. And I understand very well why this Constitutional Court dismissed our demand, did not consider even our demand, because if it's receivable, it's serious, and it is really a point of law. And they consider what we asked was not a point of law and was not serious, because reparation is ended. And it makes us in a very difficult on the low level on difficulties, because we try to prove there was, with this article, to organize to compensate the slave owner, we try to prove it was an institutionalization of inequality, of discrimination, and the state racism. And of course, it was not accepted by the states, by the states. I understand, and it put us now in a very narrow area, because as I mentioned, as a consequences, we have to now to help individual agriculture to get their land, not to be expelled from their land. And it was not our decision at the beginning. It was not an individual demand or demand. It was a collective demand, because it is a political one, in order to get the land, sure, but also to denounce the way the abolitionist movement organized the come out of enslavement. And it was not, the victim were considered as a problem, and the perpetrator, the criminals, were compensated as they were victim. And it is something we want to change. We want to see change, but it is already impossible, because we are still on this ideology of domination by race, even if it is unconscious, but the legacy, also the legacy of enslavement, is still visible, because all our world is organized through legacy of race, and in order to save the capitalism and to make the capitalist stronger and stronger. That's why it's quite difficult, but we did not resign, and we will see how we are now trying to help agriculture case by case, and we don't know what will be our next step, but there will definitely be a next step. And regarding the memorial law of Taubira, we have to understand, when this law was presented, at the beginning, there was an article to sue the state as descendant of enslaved people. But if you remember, Mrs. Taubira was member of the Socialist Party, and even from the socialist side, there was a huge demand to delete this article, because the difficulty for all the French people is to see the responsibility, even after centuries, to see the responsibility of the French population towards enslaved people.
Thank you for this. And I have to say, many of us, very much myself included, are eagerly watching what happens next with your next move in these cases, as certainly in the instance of the Kenyan claims in the High Court in London, the decision was taken to ring fence these claims around, in the case that I was involved in, around systematic torture and violence, really connecting, there were particularities to the case itself, but really connecting the question of those colonial actors acting in right of Britain, being held responsible for systematic actions, either having been part of developing the policy or not doing anything to stop it once it unfolded. And where I'm going with this is that it was consciously decided not to include claims for property loss, in part because it was very, very difficult, based on our historical research, to be able to, and this is where it gets back to where some of the work that you were gesturing to, Michael, really serves as a model. And some of that evidence has not been available to us, in part decrepit records in land courts, in part very incomplete record due to document destruction at the end of empire. And so that ring fencing really kept this case very focused on bodily harm and acts around systematic torture and violence. There was a second claim in the Mau case that did try to expand this, and I was not involved in that. It was a different set of a legal team that was involved. And the first claim was seen to be a very high watermark in legal circles, that we would ever get past it. Many of us, myself included, were skeptical about expanding that nature around property loss claims. And it did end up being unsuccessful, in part because it was very, very difficult to prove. Not to say that it did not happen, I'm not suggesting that at all, but in a court of law, to be able to document these claims. And what I see in your work, Marielle, is that kind of documentation that we're missing, as well as in the Kenyan case, as well as you, Michael. Anyway, I'm just making these observations. I'll pause there.
If I may, just I want our case is for land restitution. It's a part of reparation, but we are not asking for compensation.
Yes.
The compensation should be the land restitution. Even the land where the city hall is built in Martinique or Guadeloupe, in the stolen land, we ask for land restitution. It's something different.
I apologize. Yes, it is different, and I should have mentioned that in my remarks. And thank you for correcting me. Certainly, in the second, even in the first case, request for including land restitution was certainly part of some of the initial wishes of the claimants. For the ring fencing reasons that we discussed, it was not in that direction. And then in the second case, that has also been, that was also some of the fueling behind it. It was again ring fenced around, as I understand that case, it was then ring fenced around specific property claim. I should also add that similar kinds of land restitution claims have arisen in Kenya from the Maasai, and the maneuver that the Kenyan government, the post-colonial Kenyan government, made was to basically sidestep the incredible work that had been done by Ngate Hughes, showing that the European leases had only been 99 years and not 999 years. And they unilaterally declared that they had in fact been 999 years, thus shutting down any kind of claim with that. And so it does raise the question, at least in the former British Empire case, which is structurally different than the French, of the role of the post-colonial state within some of these claims. Anyway, your work is so generative for me. I'll pause. I feel as though I'm selfishly taking up some time here. But I will turn over, please, to Nicole. And then I'm going to raise some questions. We have several coming in on the chat.
Yeah. Now, yeah, coming back to your question about who does what to whom, I think also in the Dutch case, it's all documented in the archive. So the problem is not so much the archive, because they have historians have published on this, the UN have put a report on this. We hear all those testimonies in court of violence, often via Skype testimonies, but it's rather the imagination around that it's the injustice is too far away. So this politics of time, so that you don't have you don't feel responsible for what happened back then. And this is the difference with how we negotiate the Second World War, that the experiences of the Holocaust, this is something you really identify with, whereas the colonial and the slavery past is still, there's this historical distance. And this makes it that the way it's, the injustice is looked at, so difficult to get responsibility as a part of the dialogue. So at the very moment, we have a lot of dialogues about slavery past, and there's also debates about reparations. But what you also see is that one needs to find a language. What do you mean actually when you talk about reparations? So what we see in the Netherlands, that you actually need to find, how you translate actually the claims you have into a language which is heard by the other side, so that people feel, yes, it's about our history and we feel responsible. So it's also, it's not so much only the archive and giving proof for a historical injustice, but that this injustice is also seen as injustice from the other side. And I think this is a little bit a question of terminology, and also, to get the broader public to see how and to which extent they are part of the historical legacy, which we would like have to be addressed here also in the book.
Yes, and just to amplify that point, it certainly is in the context of the Kenyan case, there was a great deal of attention around that case at the time. And for those following the what are called the history wars and what's going on in Britain right now over the legacy, the impact of historical injustice in the empire and the ways in which that has come back to Britain, particularly through Windrush and the rest, the question about how much that Kenyan case even made a dent in sort of some of the broader public narrative around colonial responsibility. And I think I'll just make one last point before posing a question to all of you, which is the certain cases, and I'll take the Kenyan case, where it was not ring fenced around a particular moment. So in your case, Nicole, you're talking about, in your piece, you're talking about particular moments, where there's a particular, if you will, massacre, there's a particular. Whereas if one is trying to, and so in those instances, in some, the documentation becomes clearer around that if you have it, who did what to whom. In our case, in the absence of a lot of that, because of the destruction of records, we were trying to prove a system, that there was a system in place that was devised by, condoned by, and not shut down by the government. And in that sense, it was able to remove ourselves away from the precision on who did what to whom. We could have some of the broader actors that we could relate to this. But for those in the end who wanted to be part of the claim, the larger class action settlement, they had to demonstrate bodily harm. And there was an incredible amount of work that was done. I was not involved by legal teams to demonstrate that, both medically in current things, as well as through some of the documentation. But I would like to pause now a question that's coming into all of you from the chat, which is, first of all, it says, thank you all for your amazing work. This important book covers many issues in the world today, such a range of them. I'm wondering if one or more of you on the panel would be willing to talk about a just resolution to the issues that you raise. This is an opportunity to paint a picture of what our world would look like when all of us have our full human rights. A broad question, and perhaps another way of framing that is, in the ideal universe, in each of your cases, and I know this is a very big ask in a very short period of time, what would repair look like for the ways in which you have so carefully laid out the enduring impacts of historical injustice? And so I'll ask for each of you just to speak briefly. We have about 3 or 4 minutes left. I'll turn to you, Michael.
Well, quite a task in such a short period of
And a
time.
very brief period of time.
I think the top thing that comes to my mind is empowering those who have suffered themselves. Okay, it's one thing for the great powers, the United Nations, whatever, to determine the fate and the destiny of people such as Palestinian refugees. But these are people who possess rights, they're humans, and they need not be sidelined. I think empowerment on a number of levels, cultural and political, is key, including people who have been affected by violence and victimization need not only to be empowered, but be made stakeholders in their own future. I could go on, but I'll leave it at that.
I apologize. Thank you, Michael. Mariella, I'll turn to you. Oh, you're also on pause, Mariella. Same problem that I'm suffering from.
Sorry. It's difficult to answer in 1 minute, even more, even less. I could say, I think as you underline, we are faced a system, and this system is still there. And the logic of the system are still in working progress in different way, in different place of our life. I think the only way, I'm sure it is the only way to denounce the coloniality of power, the way the narrative are written from this coloniality of power, and the consequences for all the people considered as invisibilized, exclude people living in a peripheral area of the city. And we have to see also what is the indignity taking in charge by this system, the indignity to the human, to humanity, and in order to change radically the system.
Yes.
And because racism, ideology of racism is really is the basis, the fundament of the foundation of capitalist system. And if we want to get some land restitution, of course, if the French state, in our case, if the French state accept to make agrarian reform, why not? But it's not sufficient, because for the people of Guadeloupe, what they want, asking for restitution of land, is to ensure their food sovereignty and later their independence.
Thank you for that, Marielle. Nicole, I will turn to you briefly to have the last word.
Yeah, well, I think, adding to this, I think, addressing the system, so the logic of the system, and to be aware that I think many instruments of recognition are feeding the same system and feeding the same logics. So what are kind of recognition instruments who really address the structure and to get, pinpoint the hierarchies? And I think what Paul Greedy called the radical participation. So emancipation means we have to open up who is involved in these discussions, what restitution or reparation should look like. And I think, radical participation might be one answer.
Thank you, Nicole. And we could obviously each of us give each of you particularly a much longer and more robust response to that very broad and important question. But I want to end on my note of gratitude to each of you. My gratitude to you for your incredible work, for the ways in which your work crosses over into attempting to make real impact on the world in which we live, and to serving as a role model for us all. And in particular, I can speak to each of you, our students, that we so often are reading your work and are guided by the kinds of courage that you have in what you're doing. And so I will pause there. And it is a great delight now to introduce my dear colleague and friend for our next panel on reparations in practice. And that's Professor Jacqueline Baba. And Professor Baba is the FXB Director of Research and Professor of the Practice of Health and Human Rights at Harvard School of Public Health. the Jeremiah Smith Jr. Lecturer in the law school, and a lecturer in public policy in Harvard's Kennedy School. Her work is prolific. She has been a practicing lawyer for a very long period of time. The ways in which her work and her publications that have been extensive on transnational child migration, refugee protection, and children's rights and citizenship, including her single-authored and incredibly influential work, Child Migration and Human Rights in a Global Age. This range of experience speaks to not only Jackie's impact on the academy and the world writ large, but I can also say on a very personal note before I hand it over, when I first arrived at Harvard, as I was a graduate student, then became a faculty member in 2001, the very first person who reached out to me and who sought to include me into Harvard's human rights agenda was Jacqueline Baba. And that is the kind of capaciousness she has in generosity, the kind of capaciousness she has in bringing people into the fold to really impact the way in which we're thinking, and not just as individuals, but as a collective. And so I will, without further ado, turn it over to the incomparable Jackie Baba.
Thank you so much, Carrie. And thank you to the four of you for a really very stimulating and energizing discussion. I think that what I take away from it very briefly is this sense of urgency that you all express, that there have been some accomplishments, but there's so much left to do, whether we're talking about Palestine, whether we're talking about the situation in Indonesia, or whether we're talking about the French colonial state in its continuing practice of domination and oppression. So, and of course, Carrie's work too. So thank you for that. So as you said, Carrie, we're now moving on to our second panel. We're sort of marching through history. We're going from the past to the present to the future. So this is our present slot, where our panel is entitled Reparations in Practice. What has the social and political impact of reparatory measures been for affected constituencies? In other words, where there have been successes, what have, in terms of getting some reparations or getting some transitional justice measures in place, what's actually been the impact on the ground? And to discuss this, we have, again, a strong, stimulating, and very diverse panel. Unfortunately, one of our panelists, Sir Hilary Beckles, has just written to say he has an emergency, and this is how our panelists are. They're very engaged in the real world, and so, as we all know, things crop up. But Sir Hilary has actually written a wonderful chapter, which I encourage you to look at, on the West Indies. And he's a very well-known public figure, Vice Chancellor of the University of the West Indies, and really somebody who's been spearheading the struggle for reparations for a long time, as both a economic historian, but also as a kind of well-known global public activist. So you'll have to just make do with his chapter, because unfortunately he can't join us. But we have still a great group of people who I'm just briefly going to introduce. Eileen Ford is based at the University of Texas, and she's an expert on Latin American studies, and she has worked for a long time on Guatemala. So she will address the kind of legacy and the impact of reparations in that context, based on the chapter that she co-authored. We then have three good friends and colleagues from Harvard who are I'll briefly introduce them in turn. Douglas Johnson, who is a lecturer in public policy at the Kennedy School, was the director of the Carr Center, and was very well known way before he came to Harvard as an inspirational executive director of the Center for the Victims of Torture. So a human rights activist for most of his career. Phong Pham is an assistant professor at the Harvard Medical School and Harvard School of Public Health, and co-founder of the so-called COBO toolbox, which anybody who works in data collection in the humanitarian context will be very familiar with. It's a software tool for collecting in real time humanitarian data, and been kind of transformative tool for humanitarians. And last but not least, Patrick Vink, who's an assistant professor too in the Department of Global Health and Population in the School of Public Health, and the director of research at the Harvard Humanitarian Initiative. So these three colleagues and the fourth colleague who wasn't able to join us are co-authors of a wonderful chapter on Colombia. And so we're sticking with Latin America. Finally, we have Luis Moreno Ocampo, who is a very well-known public figure. He was the founding chief prosecutor of the International Criminal Court. But before that, as a kind of Argentinian human rights activist, played a pivotal role in the transition to democracy in Argentina as a deputy prosecutor in leading trials against the military junta. So this is our panel. And what I thought we would do today is to kind of invite each of you to think together about some of the kind of big issues that arise in thinking about how we come to have reparations in our societies and what that delivers. So the first question that I thought we would address is this: what political forces do you think were critical in getting the reparations process started in the context you wrote about? Which were the main driving constituencies? Which were the allies? Which were the networks? And what, if any, were the countervailing pressures? So in other words, could you paint the kind of political picture which Mireille and others have talked about is so crucial for advancing reparations claims? So Aileen, let's start with you, if I may. So the floor is yours.
Thank you very much. Good morning to everyone. Well, in the case of Guatemala, the survivors of the internal armed conflict and their organizations that they founded in the aftermath of the violence were absolutely fundamental political forces and key constituencies in driving the reparations process. Even before the accords, the peace accords were officially signed in 1996, putting an end to 36 years of the internal armed conflict, representatives between the government and the revolutionary forces in accompaniment with international actors, international governments, the government of Mexico, European governments, as well as the United Nations. We're actually now going to celebrate 25 years since the signing of the peace accords. And so we have an interesting opportunity to reflect back on what has happened and what advances have been gained or made, what allowed that to occur. And this was, the family members were pushing forward to find their loved ones that disappeared, to identify graves, and to bring forward cases to both national tribunals and international court, Inter-American Court of Human Rights, particularly, to fight for reparations, even when it was still dangerous to do so. And in the case of the case that we looked at, Sapursarco, 15 indigenous Mayan Quechua women from the El Estor northeastern region of Guatemala were absolutely fundamental in driving forward, despite many, many obstacles, pushing for justice within and outside of the court system. And they also had the accompaniment of civil society organizations, especially with feminists, lawyers, psychological support teams, communication strategists, putting together strategic litigation. The roots of that case, politically speaking, were feminist organizing, grassroots organizing from the beginning of the 2000s to recover the stories and the experiences of women, particularly and indigenous women in Guatemala, what they experienced, especially sexual violence. That was the main focus of this case in the armed conflict, which was kind of taboo to talk about. It was not really covered in depth in the historical commission, truth commissions that were undertaken after the peace accords. And so in 2010, this organizing grassroots led to a court of conscience where women from different parts of the country came and they denounced sexual violence in the context of the internal armed conflict. And they also called for accountability. And in that tribunal, or a court, there was the first identification of this Sapursarco case. So it was many years later, not until 2016, that the court actually sentenced two military officials for crimes of sexual violence and sexual and domestic slavery in that context. And the countervailing force, I guess, the force that was most opposed, as you can imagine, would be the military hierarchy, which has always tried to deny and not take responsibility for the crimes committed by its members, as well as certain sectors of the political and economic elites in Guatemala who do not want to have accountability for the violence committed because it would implicate themselves and also the structural reasons behind the violations of these Mayan Kekchi women's rights in that context.
Thank you, Eileen. So what's really interesting there is the very prominent role of feminist organizers and feminist movement in Guatemala, which I think is actually unique in our book, because it's a unique story to have a kind of sexual violations of sexual rights and the use and abuse of rape in these struggles is very common. But the leadership provided by Guatemalan women is actually a very unusual and interesting story. So thank you for sharing that. So now let's move to Colombia, moving down the continent. And if I may, let me invite Patrick Vink to answer that same question, which is what were the drivers? What were the main political forces that after this interminable conflict that you were going to talk about in Colombia that led to the demand for reparations? And again, who was kind of arraigned on the other side opposing it? So yeah, over to you, Patrick.
Thank you, Jackie. Let me first note that the number of people who worked on the Colombia chapter in this panel probably just represent the size of that reparation program. It's just been both in terms of the number of registered people, in terms of the crimes covered, in terms of the type of measures. It's a very, very comprehensive and unique effort. And in hearing some of the response and discussion today, what I think has been remarkable in the case of Colombia is the centrality of the government and the drive, the political will, frankly, around reparation. The root of the reparation program in Colombia is, of course, around the conflict and efforts at demobilizing the paramilitaries at the turn of the millennium, really, 2003, 2004. Internationally, of us probably remember those dates around the creation of the ICC, the International Criminal Court, around kind of this rise of the focus on victims and thinking around the role and responsibility to victims in transitional justice. And so the demobilization process in Colombia was quickly accompanied by an effort that tried to facilitate the reintegration of those demobilized, but also to provide some measure for victims and start providing reparations. But those reparations were very much tied to legal proceedings, very much tied to the demobilization of those former combatants. And not only had those conditions have to be met, combatants had to acknowledge what had been done, had to contribute to the reparation, but very few cases were actually happening. And so pressure mounted, and that's where really the national actors, the human rights group started to criticize the process and emphasizing the need to pay much more attention to the situation of the victims. In Colombia, in parallel to this process, you have this unprecedented large-scale displacement. Sometimes it's hard to imagine, but this is second to just Syria in terms of internally displaced numbers of people. So major issues, large number of victims. And so you've got international human rights system that is involved in criticizing and documenting what is happening. And again, this local pressure mounting that ultimately leads to the creation of what became really the victims law and the creation of the victim units and this effort to this very comprehensive effort to provide reparation. But this would not have happened without strong political will to make this happen. And I think what is interesting is those human rights groups I was mentioning have credited the victims law for bringing the actors to the table, for really centralizing or for the victims law to really demonstrate this commitment to victims of all the actors and the political will to address this issue. So I'll end here, but to know that, of course, the civil society, as in other places, has been critical, but you have this very important aspect here of political will that is quite unprecedented, and I think really led to the size of the reparation program being what it is now.
Patrick, thank you. I wonder if I could just ask a follow-up question. You note the enormous displacement, and the scale of internally displaced peoples or IDPs in Colombia is, as you say, vast. But you make a very clear distinction between the forces that were being demobilized and reintegrated on the one hand, and the victims on the other. But presumably, very often those constituencies are quite closely linked. That, like, the fighting forces are, their family members are victims. And so I just wonder if you could say a word about that dichotomy and how you see it in Colombia, because very often I think, and, Harry mentioned our class when we talk with our students too, in a human rights context, the perpetrator victim kind of divide is complex sometimes, and I think Colombia may be a good example. So just a word on that. I don't want to get us off course, but I just wondered if you or any of your fellow panelists wanted to just kind of maybe explain that a little bit more.
And definitely I will hand over if Fong or do have comments. But what I can say on this is, in part, that issue was central to the 2005 focus and the law on reparation, which was really tied around having a perpetrator and having a victim and having this kind of very dichotomous vision. But we know, as you mentioned, that the lines are very blurred, and even the lines between victims and witnesses and the experience of people. So it's interesting that there was this very comprehensive approach, but originally it was still rooted in a very legalistic process and distinction between perpetrators and victims. What happened with the victims law is that it actually becomes disconnected from a criminal accountability process. It becomes disconnected from identifying specific perpetrators. And so in some ways, you're right that you still have families of perpetrators, you have people who have been involved themselves, but we know that in most conflicts, these people are victims in their own rights. And so in the setup and the way that the victims law works and the victims units functioned, these experiences as a perpetrator are, I don't want to be caricatural. I'm not saying that they are not relevant, but they are completely disconnected from the reparation process, which was quite unique. The second aspect to your question, I just want to quickly mention, is that the Colombia reparation process happens during the conflict. So it's also not a static dynamic, in the sense that you're a victim one day, you might be a perpetrator another day. And so crimes continue to happen. And so you have this very complex dynamic. And I think that's one of the learning of this process, was focusing on victims independently of the perpetrators was, I think, an important contribution here. Doug, I see you're there. So I don't know if you wanted to add something on this.
I'm actually going to invite Doug Johnson to maybe say a word here. Doug, over to you.
Well, I just wanted to emphasize that one important source of the political will that moved forward was that the president, Santos, saw the victims program as a leverage of communicating with the guerrillas, and that it became an important element of both being able to say to the guerrillas, you created victims too, but we're going to recognize and repair the damage done by both sides. And Luis really can speak to that, because he was present at the negotiation table sometimes, where the victims unit played a very important part, and the promise of the reparations program a very important part of the negotiation process itself.
Thank you so much, Doug. So Thank you, and thank you for referencing Luis Ocampo's work. So, Luis, I'm going to ask you now. You have perhaps more experience in this field than just about any of us, because not only have you worked domestically in Argentina, but of course you, were instrumental in getting the International Criminal Court off the ground. So, maybe you could perhaps just say a word, if you'd like, about Colombia. Just following on from Doug's comment right then, and then say a bit more. I mean, this is an enormous history and an enormous question, but a bit more about what you think were the driving forces of getting this whole notion of having an international court to look at state harm and state atrocities. What were the driving forces that got that process off the ground? So thank you. Over to you.
And I focus on Colombia then, if you like. I think the critical force in the world today could be Harvard academic people. Yes, you laugh, but that you could be the center of integrating the information about 19th century problems, learning from the past, but also learning from the present. Because the Colombia case show is not a matter of the past, it's a matter of the present, and Syria is worse. So I would suggest we really need Harvard academics conceptualizing and connecting the past and the present. You started talking about Boston. I regret the prostate problem in Boston, but come on, the Syrian guys are 10 million people displaced, 5 million in Colombia. So I understand there are problems everywhere, and Boston is close to you, but that's why I started with Harvard academics. We need a brain in the world, and Harvard is the closest we have. So we need to really start to think globally, understanding, comparing gravity and comparing problems, and also demanding right things. On Colombia, I think the best I can do is tell you what the former Minister of Foreign Affairs of Colombia told me. I had a meeting with her, and I said, look, what Colombia is doing is amazing in terms of reparation of victims. No one is doing that. And for me, as a prosecutor, you're the best example on reparations. Can you present your points around the world? Can you just flag what you are doing? Oh, no, Luis, no way, no way. Why not? Because as soon as we present to the international community what we are doing, they will say it's not enough. We do 10, they say us, we do 20. We do 20, oh my God, 40. So it's never enough. So when you present this type of project globally, instead to receive support, you receive criticism. So I'm not doing that. And I think she was right. And that was for me, this idea to conceptualize what we can expect, really what we can expect. Because I was hearing the previous panel about, I saw all the limitations of the prosecution. So of course, limited. And I saw even the limitation of the reparation of specific individuals. It's a global issue. But then we had to conceptualize, okay, these are the different tools, and this is what we can do. And I think the biggest challenge, and that is for me, I need Harvard academics, is it's not about national problems. These issues are global. There are no more national problems. And Syria is the best example. Let me present, because what I'm doing now is I am representing 20 victims of Syria. And they came to me when I was at Harvard 4 years ago, asking me, they want to do a case, a prosecution case in the ICC, before the ICC. No, that's what the demand they have. And in the Rome Statute, the ICC is a place to request reparation. So the legal system is there. However, I told them, forget it. You never will get the ICC involved in Syria. Why not? Because US is involved in Syria. US is bombing Syria is acting in Syria. So US will never accept Syria sent to ICC. Russia is acting in Syria. So the big powers are killing people there. So they will not accept someone doing a real investigation there. And that is the main issue for me. You have to understand reparations. The first data on reparation is, did the abuse stop? That is for me the first question. Did they stop? In Colombia, some of them stop, some of them don't stop. In Syria, did not. And in fact, what we need is the clarity on the issue. And let me finish on that. What is the clarity? The policy in Syria was use proxy forces. And that, in fact, is a policy of a president training at Harvard. No? So you have to take responsibility of your president. And the policy was proxy forces in Syria. And that means that you were giving money and not to militias. One of my clients, the person I represent, he was working for the Free Syrian Army, and the US vet Free Syrian Army. So they check who were they. They were trying to be nice, supporting a nice proxy force, the Syrian Free Army. And my guy was a very honest guy. He received $11 million for the fight by the UK, not just US, by the UK. And Al-Nusra abducted him, tortured him, and took the money. So at the end, London money went to Al-Nusra, which is Al-Qaeda in Syria. And the funny thing is, when the claimant came to my office asking me for help then to do a criminal case, I said, no, criminal case is not possible. But in those days, the former minister of Qatar, the former prime minister of Qatar, recognized they give money to Al-Nusra. They support Al-Nusra. But he said, we're doing in agreement with the Americans. And that's the problem today. The criminals are still committing abuses. They were financed by states, not just Qatar, also US, UK, Europe. And that's why we're not talking about it. And that was, for me, we need, when I was listening to you, all the lessons learned from the past, yes, we need to learn lessons for today, because my 10 million people displaced. I'm just working for 20. That's what I can do. I can do more because I had to protect them. But the life is miserable. One of the families escaped in a boat from Syria. 2 times, the Greek Coast Guard rejected them. So the 3rd time, they sink the boat to be rescued. And the family do not know how to swim. They do not swim. So when they sink the boat, it was a really life or death decision. If the Coast Guard rescued them, they were dead. They were rescued, they now arrive in the Netherlands. But the life is complicated for them. They were rich people in Syria, that's why they reached the Netherlands. Now they are very poor in the Netherlands. The kids are in bad shape. It's complicated. How can I repair them? So that's why, for me, we need to understand this happened today, not 19th century. I like to understand 19th century, consequent today, very nice. Can we connect with today, Colombia and Syria? I think that's why we need Harvard academic, and that's why I'm pleased to be here. Thank you.
Thank you, Luis. Well, I never, ever expected that the pivot for success in reparations would be Harvard academics. I think we're a little footnote, but thank you for those comments. But anyway, you raised some very...
I'm sorry, you decide. We decide.
No, I take
we decide if you're a footnote or not. You don't need to be a footnote. We need Jackie Baba, not a footnote. That's the point. Okay. We need Jackie Baba cover page.
But I think jokes about, I think your point is a very important one. Of course, these are incremental contributions we make in the face of absolutely overwhelming and vast atrocities, and so there is always this tension between the kind of limitations of what we do. Even you as at the ICC, there are always going to be limitations. But I think it's interesting. I mean, thank you for raising this big geopolitical picture, which maybe we neglect. I mean, of course, as Carrie Elkins was saying in the previous panel, they did manage against this fearsome British Empire actually win these cases. Now, of course, it's 5 cases, and her new book is about a much, much broader canvas of unrepaired crimes by the British Empire. So it's not a full victory by any means. But on the other hand, there are these steps to making some progress, which I think are of course, are very important. So maybe we can move on to the second question I wanted to raise, which is when you're looking at reparatory measures, at reparations in your context, in Guatemala, in Colombia, in the world, or in Syria, what are the key indicators that you focus on? And if you think of the previous panel, I think Nicole put it very well about, this individual remedies versus group remedies, and I mean all the panelists actually, Mireille and Michael as well, that there are some moves that address individual harms, individual property, individual claims, but of course then there is the destruction of the whole community, the theft of land. These are enormous unrepaired issues. So what are the indicators that you focus on, you think are significant? So maybe we can start, and part B to that question is, which presumably the answer is no, is there a consensus about what is important? So let's start with you, Eileen, in the Guatemalan context, please.
Well, in our chapter, Dr. Velázquez Nimatuj and I focus, I guess you could say, on symbolic indicators or impacts and also material impacts. On the one hand, symbolically, the court sentence and reparation measures set a historic precedent worldwide. It was the first time that a national tribunal had condemned sexual slavery in the context of a conflict situation. And it was also in Guatemala the first time a national tribunal had held accountable or condemned 2 ex-military officials for crimes of sexual violence in that same conflict. And so it was also a chance for these indigenous women to, in their own languages, from their own cosmovision, organizing and calling out, breaking the silence, returning the culpability or the shame to the perpetrators of sexual violence, inviting other women to come forward and to also denounce what they had been through. And they were highlighting specifically the historical injustices that had created the situations that allowed the violations of their human rights to take place. So it was a legacy of a continuum of violence against indigenous women in Guatemala as a result of colonialism, of racism, and of patriarchal social relations. And we see this.
So just to interrupt you, Eileen, for a second. So going back to the big picture. So you're saying one kind of impact was just, or one indicator of impact was just the record, that this was the first time that, sexual violence had actually been judged and found to be a violation which was justiciable. So that in itself is it's nothing to do with money. It's changing the record, changing the history, changing, what your kind of account of that period of Guatemalan history was. Is that right?
I think that's fair to say. And I do wonder about what kind of impact moving forward in other situations like the Yazidi women in Iraq and different situations of sexual slavery, if this could have any kind of an impact down the line. Yes, in terms of material reparations, the Guatemalan case shows just how hard and the great limitations that there are to actually implementing the reparations. In the case of the Seposaco women, the state was supposed to be responsible for implementing 16 specific reparation measures through their ministries. And the most that they have advanced on is translating the sentence into a few of the Mayan languages, putting a temporary community and starting the process for restituting land that was the main issue at the heart of why the women faced sexual violence in the first place. But we see there how the state is the lack of political will in comparison to, example, for the Colombian case. It really struck me reading that chapter, the difference in the political will and how in the Guatemalan case, we see very clearly the lack of political will on the part of a state policy to actually implement these reparation measures, in part because they would touch upon historic political and economic interests, especially land tenure and indigenous rights, which are at the core of a lot of the conflicts today in Guatemala and the violence that you see against indigenous women to this day. So, for example, they never restituted the land that the wives and the husbands of Sapursaco, they were organizing to get land tenure, basically. And so the court in the reparations measure said that they needed to continue that process. But the government last year, the president of Guatemala, Alejandro Giammattei, he abolished the Secretariat of Agricultural Affairs that was in charge of doing the buyback from private landowners to transfer the land to the indigenous women.
Sorry, we've slightly lost you. But anyway, thank you. I'm just going to interrupt because I think we've slightly lost your voice here with the Wi-Fi. But yeah, so very important point about I mean, this complexity about actually what the material measure is, which is also, of course, very relevant to current debates in the US and elsewhere. How do you quantify what? And you know, many colleagues and many activists are working on this right now. So that I think is a recurring point. But then also, you know, the question of the hostility of the regime to actually challenging current interests, and it's the point that Mireille made and others. So yeah, so thank you for that. Okay, Patrick, let me invite you to perhaps take this on too. So you already mentioned, and Doug and Fong too, you already mentioned how ambitious and capacious in scope the Colombian whole reparatory experience and experiment, if you like, has been. But what are the key indicators that you think in Colombia people have focused on to say that this has been successful or been unsuccessful or partially successful? What are the key measures that you would say are particularly significant? And insofar as they have been significant, are they continuing to build, you know, integration? Are they continuing to build a sense of well-being, sort of setting the clock away from the conflict, or are they perceived to be very precarious? So, I mean, these are maybe difficult questions to answer, but I would love to get your collective sense of this.
No, thank you for this. I mean, obviously working on indicators and measures is something that Fong and I spend a lot of time on. And, you know, at the most basic level, it would be fairly easy to tell you, well, yes, of course, we need to look at reparation in terms of the extent to which victims feel recognized, acknowledged in their experience, whether they regain some sense of dignity and agency through the reparation process. In addition, of course, to their material improvement, if any. We can look at memorialization and whether there is a sense of history being known, understood, documented, whether there is a sense that even the guarantee of non-repetition is meaningful from the part of the state. So there are many aspects that we can judge a reparation process against. In the case of Colombia and in our chapter, one aspect of the many that we looked at is I think really more reflective of part of the aim that in fact Doug mentioned as well, of the government and the president, which was really trying to use reparation as a mean to mend broken relations, to really instill a sense of relation, of increased confidence among the population towards the government, really working on that social contract between the state and the people that it is supposed to serve. And so one of the aspects we were really interested in is whether that social cohesion, that vertical social cohesion, that relation between people and institution was broadly changing as a result of reparation. And so aspects of trust in government, not just trust in the reparation process, but whether it had broader impact on engagement and recognition of their government. Now, what's interesting is once we frame it along those indicators, then what we realize is that it's not just about what is being done. It's not just about whether people received some form of compensation, payment, land restitution, were able to return or not. It's also about the process, and Doug can talk about that because he really looked institutionally at the setup of the victims unit. But then it leads us to ask question, okay, if this process is perceived as corrupted, as it is largely, unfortunately, in Colombia, then it cannot contribute to that objective because the process is not perceived as being fair. It may actually not be corrupted, but if the perception is that it is, then that objective cannot be met. Same with kind of a sense of misunderstanding of who is receiving reparation and who is not. An impression among the people we interview that it's random, it's not based on harm, so we don't know when we are going to receive something, we don't know what's happening. And so this kind of outreach understanding becomes really critical indicator of the likelihood of success of reparation. And so for us, it was a really interesting example highlighting the importance of both looking at outcomes and thinking about long-term changes, but also the process and whether the institution is set up in a way that can achieve its goal.
Thank you. That's really quite fascinating. Doug, I don't know if you would like to jump in. I think, you know, also I'm struck by the historical parallels and contrasts. If you think of the, you know, the colonial situation that people on the first panel talked about, where there's absolutely no sense of integrating vertically across these very fractured societies, whether it's, you know, Dutch and Indonesian or French and Guadeloupean. This Colombian situation, of course, and maybe Guatemalan situation, I don't know, Eileen would know better, are really different. But so Doug, yeah, I would love to hear your anything you'd like to say about the victims units and follow on from what Patrick just said.
The first of all is to emphasize the question of scale. In our review of reparations programs, historically, we found that the largest program reached out to about 2% of the population, whereas the Colombian program was closer to 14%. So an enormous difference. And that was a very telling issue on the question of the state's capacity to fulfill. And I would emphasize again something that Luis said. The Colombians used the international touchstones for what a reparations program could be, 5 different points, including the guarantee of no reparation, no return or no repetition. So they tried to develop programs on all 5 of those areas. And then it was a massive issue. And then the Colombian courts required them also to include all of the displaced. And that almost tripled the size of the people who needed reparations now legally. So in the attempt to create a far-reaching and perfect program, it became an impossible task institutionally. They decided the best thing was to create a new governmental unit, the victims unit, which starts with 1 person and is somehow to address the needs of 14% of the population. So while we're there doing an evaluation of the program and its effectiveness, the size of the organization keeps changing dramatically, sometimes over several months, 2,000 or 3,000%. And that represents a terrible danger for any institution to grow so quickly. The ability to find good staff and to train them and to orient them and decide the measures of success for this very broad range of issues. And so in that sense, in many ways, the best became the enemy of the good. And as Patrick said, people thought it was random. And that was because the political leaders and the victims leaders refused to actually create a priority, a strategy that said, first we'll work with this group, then we'll work with this group. They thought that it was politically necessary to work with all kinds of victims, but given the limited institutional capacity to do that, it looked random. And one of our recommendations was that the president needed to set a strategy so that people could actually understand what was going on instead of it appearing random, to really create the opportunity for success for the new institution and let it grow and build in a more productive and measured way. So I think the Colombian minister was right that no matter what they said, they would be told it wasn't enough. And in the Colombian situation, even though it's the most massive program in the world, even to date, nothing was enough because it couldn't well manage the difference between the expectations and the specific organizational questions on their ability, their capacity to deliver.
Thank you. No, that's really very thought-provoking, talking about 14% of the population, the mind boggles. Phong, I wonder if I could just draw you into this conversation and invite you to maybe share a couple of comments, because I know you were centrally involved in this work as well.
Thank you, Jackie, and thank you for having us. Yeah, I think one of your questions was also about impacts and whether reparations can heal society and political wounds, right? And so I think for us right now, I think, as you said at the beginning of this introduction, was that, you couldn't believe that this is all happening. So we still need to collect a lot of data to find out whether this will have, but I think there's promising signs. And I think some of the key factors that I think could, and as Patrick mentions, could determine whether will have an impact is really to monitor the process, not only the outcomes, but we need to really monitor the process of implementations. And from public health measures that, it's just not just like delivering vaccines, right? It's how you deliver a vaccine and how you message the vaccines. So that's going to be really important. And I think there's other factors that we also need to consider too. And one is whether victims feels their harms are recognized and acknowledged. So how do you deliver that message? How do you convey that the government and the entity care about the harm that they suffer and acknowledge that? And I think the ultimate though indicator, and one that Doug mentioned, is the guaranteed of non-repetition, that violence will not occur again. So no matter what happens, everyone talks about, they want opportunity to rebuild their lives. They want opportunity for their children's. So the extent that they can rebuild will ultimately, measure the success in Colombia. And so I think that guaranteed of non-repetitions, and I think a lot of that will also tie to some of the accountability measures. I think Patrick mentioned earlier that, Colombia was quite unique, that the reparations was implemented prior to the peace negotiation process concluding. And so it was independent of these accountability measures, but I think victims felt like even if they did receive reparations, they still want accountability. And so that, and you saw that played out during the elections and the ratifications of the peace negotiations. So I think some of that will we have to monitor that to see the success of the reparation program.
Thank you, Phong. Thank you. I think I wanted to ask another question of all of you, but unfortunately we're out of time. But thank you. I think you put it beautifully, bringing together these different strands, the acknowledgement, the truth telling, if you like, the record correcting and setting the record straight on what has happened, A. B, the whole question of actual material reparations, but C, probably most importantly, getting on and living your life in a way that's dignified and that generates well-being for you, your family, your community. So this, of course, is at the core of all this reparations work. So unfortunately, we're out of time. So let me just thank you all for really excellent, thought-provoking comments, and look forward to engaging further as we go forward. And now it's my great pleasure to hand the mic, the virtual mic, so to speak, over to my my close colleague and friend, and the director of the FXB Center's Roma program, and very much a kind of inspirer of much of the work that we do, Dr. Margherita Matake. Magda has been at the FXB Center now for over a decade, and she has really built up the work that we do at the center, but also more broadly at Harvard on Roma rights. And I hope you all notice that I'm wearing my Roma shawl today to celebrate Human Rights Day. But Magda's very involved. I mean, she is also, as Luis noted, a Harvard professor, but she is very involved as an activist in the struggle for reparations, which are really outstanding in many contexts, including in the Roma context that she is most passionately engaged with. So Magda, let me hand the floor over to you and invite you to chair the final panel. Thank you.
Thank you very much, Jackie, and hello, everyone. Thank you for joining us, and welcome to our third and last panel entitled Outstanding Claims. I think that many of the panelists earlier underlined that there have been calls for reparations for collective injustices and harms at the global level, basically reaching many parts of the world in the past few decades, and more so in the past few years. Yet somehow reparations programs remain remarkably scarce or inexistent if we were to think about reparations for enslavement, for example. And most often, state institutions and other public and private stakeholders avoid responsibility and accountability. In other words, there are many outstanding claims that wait for acknowledgement, recognition, restitution, memorialization, apologies, compensations, reforms, and other forms of and methods of reparations. Our discussion today will focus on 4 such cases of outstanding claims, which have been discussed by our panelists in their book chapters included in the Time for Reparations volume. I'm talking about the Roma genocide during the Holocaust, as well as colonization and slavery in Jamaica, starvation crimes, and Algerian archive restitution. But first, please allow me to briefly introduce the panelists, and you can find their full bios on the event page, which Veronica kindly posted earlier in the chat. Ian Hancock, OBE and Fellow of the Royal Society of Arts, is Professor Emeritus at the University of Texas in Austin. Bert Samuels is an attorney and member of the Jamaican National Commission on Reparations. Bridget Conley is an assistant professor and research director at the World Peace Foundation. Alex Deval is the executive director of the World Peace Foundation, as well as research professor at the Fletcher School of Law and Diplomacy in Boston. Susan Slimovich is a distinguished professor of anthropology and Near Eastern languages and cultures at the University of California in Los Angeles. Welcome, everyone, and thank you for contributing extraordinary chapters to our volume. And thank you for joining us today. I will be asking the panelists a few questions, and I hope that some of you in the audience will also post some questions in the Q&A box, and I'll try to make sure that our panelists will discuss them. But to get the conversation started, I would like to ask each panelist to take perhaps about 5 or 6 minutes to discuss the importance of reparations in tackling unaddressed forms of injustice. And I want to ask you, what methods of reparations do you suggest for the issue addressed in your chapter? And perhaps Professor Hancock or Kakoyan, Ian, let's start with you.
There we go. Thank you, Magda. My chapter in the new book, which I haven't received yet, deals with the slow pace of recognition of the fate of the Romani genocide in the Holocaust. And in terms of reparations, time is a major factor here, because the people who were victims, the survivors of the Holocaust, the Romani survivors, are passing away all the time. There are very few left now who would benefit from receiving any sort of compensation. So the question really is, in our effort to receive compensation, remuneration for the genocide, who would it go to? One of the reasons for our taking a back seat in Holocaust studies, it's complicated. There are a number of factors. One of the major factors is that we as a people, and we are in fact the largest minority group in the whole of Europe, numbering in the millions, but we do not include in our number enough educated people, and going back to the late 1940s, after the end of the Second World War, even fewer then, to make our case known. That is slowly changing, but very slowly. And to understand why that should be, we have to understand the history of our people. And when we look at responses to the genocide, glaringly, we have examples of complete ignorance about who we are, where we came from, why we are in the situation we're in today. We have history of slavery and expulsion and a genocide attempt a few hundred years ago. This wasn't the first. If we look then at the responses, many of them have been rooted in ignorance. For example, when Germany was asked about reparations for Holocaust victims, they reached a point where they said the extent of our applying reparations ends here. No other groups will be considered. Why Romani people were not considered was because the argument was being made that Romanis were not being targeted for racial reasons, but for social reasons, because we are criminal. But when you look at the documentation, it's clear over and over and over again that the Nazis saw criminality as a genetic condition, a racial condition, but that was not acknowledged at the time. When I was on the US Holocaust Memorial Council, members would ask, what exactly are gypsies? Are they actually a people? This sort of ignorance it's chilling, and it's there because we do not have the voice necessary to speak up for ourselves. The US War Refugee Board, the War Crimes Tribunal associated with that, had the documentation that mentioned the genocide of Jews and Romanis. And yet we were left out of the documentation allowing reparations to be made. When the Swiss banks, when it was revealed that there was money secreted into bank accounts in Switzerland, the available money was made, the amount, and a board was set up of lawyers to determine who should get this. The question was, or the requirement was to have different bodies submit project descriptions of projects of how they would benefit if they were to be if they were to receive reparations. But we engaged a lawyer, actually, the main lawyer on our newly created organization was Ramsey Clark, the former Attorney General. We also had Sebastian Reynon. We drew up a complicated and very detailed submission, which included the creation of several Romani centers. There were about 12 of them in major cities in Europe, and one in North America, one in South America, which would be linked together by computer. It would have the content of the Romani archives digitized and made available everywhere, not only for young Romani people, but for anybody who wanted to learn about us. It would also provide grants for scholarships for young Romani people to attend college and so on. We were not asking for a great deal. I think the amount that we claimed for was 20 million, not a huge amount, but given that the percentage of our losses matched the percentage of the Jewish losses, and we are talking about genocide, we thought we had a very legitimate claim. We still do. A very few people have received minuscule amounts, $5,000 here, $2,000 there. But it's not enough. And as I said at the beginning, the people who deserve to be compensated, the number is growing smaller and smaller every day. So this is what my chapter has dealt with, and how we have been dealt with by Holocaust organizations. And it's very emotional for me to talk about this, but perhaps I can give more examples a bit later on in the session.
Thank you very much. And I think that for many of us in the Roma movement and in the Romani studies discipline, it feels oftentimes shocking and so upsetting to actually see that the scholarship continues to claim that the reason why Roma were sent to the gas chambers was not a racial one, but it was mainly criminality, as if criminality wasn't a racial construct. At is only in the case of Roma, criminality was an inborn issue, and it remains as such. So I think it's so, I'm so grateful for your contribution in this volume, and I think that your chapter is crucial also because in the scholarly context, we see that the post-Holocaust reparations programs have been seen and remain an exemplary model, if you will. And often these post-Holocaust reparations are used to inform claims, movements for reparations, and scholarships in other countries. And we know that, for instance, Ludi and others argued that, and rightfully so, that the post-Holocaust reparations have radically changed our understanding of reparations. Yet, as you evidenced in your chapter, but as others also argue, Afro-Germans, LGBTQ+ people, Roma have been historically overlooked in reparations processes and programs. And of course, I think that Michael talked earlier about Palestine, and here it's also another critique that we can think about. And I hope that we, in the second part of this conversation, you tell us more about your vision about what needs to be done. But perhaps we can move forward, and I'd like to invite Bert Samuels to take the floor. And Bert, it's such a great honor to see you again. You presented in 2016 at the annual Roma conference, which in many ways was the seed of this volume. And many of us were inspired by your work on reparations. So I would like you to take the floor and share some thoughts with us.
Good morning in Jamaica. It's good to be here again. I had the great privilege of 2016 being invited to speak at the Harvard Range Conference. And I learned so much from my other sufferers at the hands of colonialism, at the hand of discrimination. My chapter in this work has to do with the question of enslavement from the transatlantic slavery, as Jamaica, among several other English-speaking islands, were the point from, we were taken from Africa by ships and brought to the Caribbean. And I would say that the ancestors are indeed pleased that I have found myself among the 16 other contributors in this historic work, Time for Reparations. This project, though conceived of some 5 years ago, has been buttressed by the worldwide awakening of the 2020 Black Lives Matter movement. It is in truth the time for reparations. On this International Human Rights Day, this discussion is welcomed, so that just going historically, on the 1st of August, 1838, some 183 years ago, my great-grandfather, Edward Samuels, was a young enslaved infant whose fate changed with the grant of freedom. He nonetheless lived through a post-slavery system which continued the legacy of slavery. His owner was compensated for his loss, and the entire compensation to those who enslaved us in the English-speaking Caribbean territories was £20 million in 1838. At this time, this amount represented 40% of the British annual budget, a debt which was, though being repaid 6 years ago. This debt on the English budget was through being paid 6 years ago in 2015. It is this egregious act of paying the enslavers for their loss of the enslaved and leaving the newly freed landless, unpaid, and uneducated that makes the time for reparations a justified call. Enslaved persons were branded with hot iron. This was admitted by Reverend Besant, who explained the church's involvement where the Society for the Propagation of the Gospel branded its slave with hot iron, SPG, in Barbados, an island in the Caribbean. Today, the Caribbean's underdevelopment is inextricably linked to the legacy of slavery. We need education to be funded. We need to expand our health sector where patients do not die because they can't afford primary health care. So that in Barbados, type 2 diabetes, directly related to that which was fed to us during our enslavement, have the second highest amputation in the world. May I repeat, Barbados have the second highest amputation of persons in the world because of the prevalence of type 2 diabetes. We have in Jamaica a serious problem of self-hate, where the bleaching of the skin to lighten its color is popular. The lighter the complexion, the more acceptable persons are in the complex self-hate culture. This was taught to the enslaved Africans during their enslavement. This mental illness, where persons are discriminated against by European colonizers based on the shade of their skin, led to the Rwanda massacre, which we will all recall. The leaders in the Caribbean in 2016 penned letters of demand for reparation discussions to commence to their respective former slave-owning European countries. The response has been from all these European countries in 2016 to be met with denial and refusal. They simply are not prepared. The French, the English, the other European, Portuguese, have all refused to sit at the table for reparation discussions. Institutions like universities, who were funded from slave labor, have been slowly leading the way in compensation and acceptance that there must be reparations paid to the descendants of slaves. Of course, the cost of repair is huge, but the claimants should not be blamed for its size. Transatlantic slavery lasted over 300 years, and hence the debt to the problem, no pun intended, of necessity is enormous. Our call for repatriation of artifacts is part of our call for reparations. In 1792, 2 statues were taken from a cave in Carventer's Mountain in Clarendon, Jamaica. These 500-year-old, 3 feet tall wood carvings were that of Birdman and a rain god, which are both works of art and treasures to the Taíno people, who you will recall were victims of genocide at the hands of the Spanish invaders from whom the British captured Jamaica. They are sitting, that is, these carvings, these artifacts, 500 years old, are sitting in the British Museum, a part of its tourist attraction. And there's a refusal, notwithstanding our request, to return these artifacts to Jamaica. There is the horrible case of enslaved persons being thrown overboard on the ship called the Zong on its way to Jamaica in 1781, where a decision was made when the ship ran out of water to throw enslaved persons overboard and thereafter make a claim on the insurers. This claim, which became a case, is recorded in the law books of our English courts. The call for reparation will not disappear. We have in Jamaica agreed to the filing of a petition in the British court called the Privy Council for a declaration that our enslavement was a crime against humanity. We hope that this will be heard next year in 2022. The ancestors deserve that we make this case on their behalf. This indeed is a time for reparations. Thank you.
Thank you so much, Bert, for this powerful presentation, but also for your chapter, which is as powerful as your words here. And I want to say once again that your work and ideas, as well as the work of CARICOM, have really paved the way for many of us who think and imagine methods of reparations for the history of enslavement in our own context. And I think there are so many ideas that you brought into the conversation today, and I see so many similarities, for instance, with the plight of Roma people in Romania who were enslaved for 500 years, and Ian Hancock has written and researched about this for a long time. And I think that one commonality which we see in our context, but also in others, is really the fact that the enslavers were the ones who receive compensations to allow the enslaved people to actually become free. And that's really part of this whole conversation on reparations, which doesn't mean only compensations for the exploitation, but really to look back at all this money that the enslavers actually received to free our ancestors. So thank you so much once again. But let me continue, and perhaps we can all continue our conversation and talk about starvation crimes. And Bridget and Alex, you co-authored another powerful and extremely compelling chapter on this topic. And I would like to invite you both to answer my initial question, and perhaps we can start with Bridget, and then Alex can add as well.
Thank you very much. And thank you to my fellow panelists for such moving presentations, and to the editors of this volume and host today. So I'm going to speak sort of in more broad and overview terms about the question of reparation for starvation crimes. And then Alex is going to speak about what this means in a very particular context, that is Ethiopia today. So the topic of reparations for acts of starvation, and more broadly justice for those who suffered famine, is in many ways a project of making harms visible. There's an array of scholarly and legal resources that are relevant to the project of understanding acts of starvation as crimes and the ethical project of prohibiting them. But there has been a gap in terms of applying these laws and concepts to this question of starvation. Our chapter was an attempt to map this conceptual terrain, and we would like to encourage people in the audience who are able to do so to pick up this charge. It needs more research, more activism, more engagement. Our work on accountability for starvation over the past few years began with Alex's examination of the possible end of famine. So famines declined precipitously in our lifetime, and they're on the verge of disappearing from the category of ongoing traumas, when in 2017, the UN announced 4 sites of ongoing or threatened famine in Yemen, Somalia, Nigeria, and South Sudan. And as I noted, Alex will address another that should be added, Ethiopia. All of these cases are in war zones or areas of active political repression, and there's a simple explanation for this. Famine today only occurs where policymakers and warring leaders implement policies that intentionally create and sustain mass starvation. This may occur through siege. Syria provided many examples, where even previously food secure populations find themselves bereft of the means to sustain life. It also may occur in areas where food security has long been a hardship of everyday life, but where policies strip entire populations of the few guardrails that had previously kept them from collapse. Our work on starvation crimes over the past few years has attempted to use the language of international law as a clarifying lens, bringing the intentional policies that create mass starvation to the fore and demanding that victims of these crimes be treated with the dignity and gravity that is their due. So I'm just going to briefly introduce some of the key concepts that have formed our work as an instruction of how we might use the language around reparations and accountability to see the crime of starvation. So famine is large-scale hunger, destitution, and elevated mortality. It's defined not only by scarcity of food, right, by lack, but also by the failure of people to have the means to access what food might be available. So famines are distinct from chronic hunger and malnutrition. They're spectacular and terrible outbreaks of extreme distress. The intersection of gender and famine provides us an example. Globally, women and girls suffer more from chronic hunger than do their male counterparts for many reasons. But during famine, right, during this extreme suffering, there's often what is referred to as a female mortality advantage, and that males die at higher rates during extreme events. The female advantage, such as it is, which is simply not to die, not to protect them from suffering, too often means that survival means living in context of extreme biological, economic, and also social disadvantage. Starvation crimes is a term that we proposed and which covers a range of criminal acts that include 3 central elements: an outcome that includes deprivation of food and associated suffering. And this is not necessarily mass starvation unto death, although death and some such outcomes are relevant to demonstrating the gravity of the crime. So one is the outcome. 2 is the act of depriving persons of food and destruction of other means that are indispensable for survival, right? So the actions. And then 3 is criminal intent. Starvation crimes draws on already criminalized acts. These include attacks on objects that are indispensable to the survival of a civilian population, such as are already prohibited in international humanitarian law, also in the Rome Statute. Other war crimes might also be relevant: willful killing, torture, inhumane treatment, extensive destruction of property, intentionally attacking civilians or civilian objects, pillaging, and so forth. Various acts of famine can, when directed against a population in a widespread or systematic manner, constitute one of several crimes against humanity: murder, extermination, forced displacement, persecution, other inhumane acts. We also find resonance in the Genocide Convention's reference to creating the conditions of life that would bring about a group's destruction. But despite this resonance within accepted and active law, right, in terms of the courts and other forms of reparation, we have not seen starvation crimes take center stage. And despite the fact that they often impact enormous populations and numbers. So reparations for these crimes, whether in the form of prosecutions, compensation, truth-telling, right, even just the basic facts, memorialization, or even apology, are exceptionally rare. And so the work of advancing any of these forms of reparation would go some distance to the key endeavor that has been at the heart of our work: making starvation visible as the product of intentional policies. The image of the malnourished mother and child, right, the disaster industry's Madonna, leaves key agents outside the frame: those who actively foment starvation policies. The work of advancing accountability for starvation, right, of reparations, instructs us to pull them back into focus by asking, who is starving whom? Now I'd like to pass over to my colleague, Alex Duvall.
Thank you, Bridget, and thank you to Jackie, Margarita, and Caroline for inviting us to contribute to the volume and to this important and very moving event today. So I want to talk briefly about a case that is not in our book, because it is unfolding now. It has only been occurring this year, which is the mass deliberate starvation of the population of Tigray in Ethiopia. Which is not in the news because part of the arsenal of those who are inflicting the starvation is a strict control over information. No journalists have been allowed into the area afflicted by starvation since June, and the ones who went in June snuck in illicitly. Even United Nations and aid personnel are prohibited from reporting on what they're seeing. If they come out, the few that are allowed in, when they come out, their cell phones are confiscated so that all the images can be wiped before they're given them back. So out of sight, out of mind, out of policy focus. It is actually, in my view, and I've been working on this topic for almost 40 years, the most sustained campaign of faminogenic action on the record. Crimes of pillage, the destruction of objects indispensable for survival of the population, intimidation, rape as a way of starving people. A woman or girl who is a survivor of rape may not be able to care for herself or her children, and the fear of sexual violence deters women and girls from undertaking essential everyday activities, and siege and obstruction of humanitarian assistance. The Prime Minister of Ethiopia, Abiy Ahmed, said, perhaps with more candor than he intended a few months ago, that he'd reduced Tigray to the level of Bashasha. Now, Bashasha, when he was growing up, was the small town in southern Ethiopia where he lived, which was extremely poor, deprived of basic services, in a state of chronic food insecurity. So he heralded it as a success of his war aim to put this region back approximately 40 years in its development, to a time when many of us will recall Ethiopia was known as the land of famine. I think it's actually worse than that in Tigray today. The most important initial step is recognizing what is going on. And as I indicated, there is an attempt, a successful attempt at the moment, to conceal what is going on. I'll very briefly indicate the perpetrators and what we might think of in the way of reparation. So the perpetrators are the government of Ethiopia, the federal government that is, and its army, the forces from the next door region of Amhara that have participated in the military campaigns, the atrocities, the ethnic cleansing, and the government of Eritrea, the state next door, that has been actively engaged in warfare and atrocities without being internationally recognized. All should recognize the crime, all should apologize, all should be liable for restitution, compensation, and reparations. But the challenge is, even if there is some political change or some change in heart among the perpetrators, will they have the resources to do this? Because these are poor countries and they are getting poorer by the day by spending their money on weapons, not on economic development and welfare. So they will have very meager budgets. What therefore we ask is the responsibility of the international community. And I think that the first step is for us, the international community, to recognize the crime, to give the victims and survivors that quantum of solace that they are being recognized as victims of a crime rather than having themselves failed, being ashamed of being unable to provide for themselves. The UN and others have not used the mechanisms at their disposal to respond. The international aid has been very meager. The calling out of the Ethiopian government has been almost non-existent over the last few months. And there's an additional twist here that much of the infrastructure that was destroyed and pillaged, vandalized, was funded itself by international aid donors. Our own aid dollars or aid pounds, I've been paying tax in the UK as well, funded agriculture, funded water supplies, funded all afforestation schemes that have been destroyed by governments that we continue to recognize as I call development partners. So are we under an obligation to earmark our assistance to Ethiopia, to go to Tigray, to penalize the Ethiopian government and other poor people in Ethiopia by directing aid to that area because their government perpetrated these crimes? There are some very complex questions of ethics, of law and policy that have yet to be addressed internationally, none of which should, of course, dilute the immediate responsibility of the direct perpetrators, but these are perhaps tools that are more within our grasp than others that might be available. Thank you.
Thank you very much, Bridget and Alex. Very important and much needed contribution. And I think that in many ways, your presentations, as much as your chapter, brings me back to an idea and a phrase that the Rome Statute of the International Criminal Court uses, and this idea of the conscience of humanity. And in many ways, in thinking about how ordinary this whole conversation about starvation crimes and mass starvations has become in an age in which we are connected globally in so many ways, and with a click on social media, it just feels that the consciousness of humanity is missing. It feels like we just accept the fact that millions of people are dying as a result of mass starvation, and I think it's perhaps a question to think about for later on is really, what can we do, and why isn't this practice, this form of mass murder really shocking us? Why isn't it that the world doesn't react to it? And I'm not talking only about international organizations, but I'm talking about all of us, each and every one of us. And then Bridget, you mentioned the various methods of reparations, and you touched upon the idea of apology, which doesn't engage money, doesn't involve a lot of commitment. It engages 3 words or perhaps 5 words, but yet in many environments and many contexts, including in the context of enslavement, most of the time governments and those who are the perpetrators, they just refuse to say I'm sorry. And so I would like to hear a little bit more from you after we finish this round of questions, and perhaps we can move on now and talk about the Algerian archive restitution. And Susan, I've admired your work for a long time, so I look forward to hearing your thoughts and ideas about reparations, but also about what we can do. So thank you so much for accepting our invitation and for writing such an amazing chapter.
My thanks to panelists, organizers, and of course the book editors. So my book chapter concerns Algeria and France in the 132 years of French colonial rule. In the early decades of French colonization, many, not all historians, agree that 1/3 of the native population died alongside other depredations, land dispossession, massive internment, forced labor, famine, widespread immiseration. So my question is, what is the role played by restitution, which is defined as a component, a subset of the umbrella term reparations? Those are the UN definitions. In Algeria, restitution is deployed for the unjust French acquisition of archives and objects as cultural property, notably when such injustices are embedded in colonial occupation and genocide. So the Algerian claim for restitution maintains that the French state has an obligation to correct the crimes of colonization, and that restitution as a subcategory of reparations is an appropriate form of redress for widespread looting by force and spoliation. And in my book chapter, I talk how they were inspired by Frantz Fanon, who was a member of the Algerian Liberation Front. Now, the archives of French Algeria remain largely in French hands, so the historical linkages are there between France's settler colonial project in Algeria and ongoing disputes about archival sovereignty, provenance, and digitization. So in general, Franco-Algerian restitution cases are this mix of legal, moral, and practical concerns. So I'm just going to give a list as the rest of my talk, basically with a short conclusion. What are the limited French solutions? What are the French tools since Algerian independence in 1962? And what have been some of the Algerian responses? So first, similar to what we've heard, Jamaica, Guadeloupe, the Roma populations in Romania, France similarly has provided several substantial financial indemnification programs. So financial reparations go to the European settlers for the loss of the prize Algerian colony in 1962, but it never goes to the colonized. The second French tool is piecemeal diplomatic gifts that France has provided to Algeria. And here's why they're important. In 2007, finally, the French army released maps and documentation for mines placed along the length of the electrified Algerian boundary fences with Morocco and Tunisia. This was all done in the 1950s, but with no French acknowledgement of the massive number of Algerian dead from the mines between 1950s and 2007, and there's no agreement on the figures. In 2020, now that holding human remains is shameful and unethical, 23 decapitated skulls of some several hundred of 19th century Algerian resistance fighters that had been sent to the Paris Ethnology Museum for study were returned on July 5th, 2020. Number 3, there have been case-specific French Senate laws, but only passed to cover individual objects, and we're talking tens of thousands of objects, and only from sub-Saharan Africa, Algeria, and Egypt, which includes Napoleon's stolen objects. So we're going really far back. All have been excluded. There is no admission, there is no repentance, and the few cases of sub-Saharan object restitution, which are to Benin, because this has been a European project, have come with no apology. And the French Minister of Culture congratulated French museums for their role in preserving artifacts and making them universally available in their museums. The fourth tool is digital portals and inventories, archive digitization, but there's no agreement as yet who gets the original, who gets the copy. Algeria has so far refused the copy. Germany and the Netherlands are the most advanced in terms of digital inventories. France is the least. The fifth, extended loans, not yet implemented between France and Algeria, but between France and sub-Saharan Africa. Number 6, targeted commissions for Algeria. The first ever was the Stora report this year, January of 2021. It was a commission that was commissioned to create a Franco-Algerian commission. And it's several modest solutions, which are, again, digitization and the possibilities for ease of access, which basically came down to a dozen annual visas for Algerian scholars to come to France. Apologies, number 7. Here I'm just going by the Institute for the Study of Human Rights website at Columbia University that tracks apologies worldwide. Again, just like financial indemnification, apologies are mainly to the Algerian diaspora who are now citizens of France. And otherwise, there are very few official French pronouncements to Algeria. They are formulaic, they are limited, and they are belated speech acts of acknowledgement, and they are demonstrably not pardons. Instead, of course, there are wholesale amnesties that materialized after the Algerian War in 1962. which hew closely to an institutionalized amnesia, certainly vital to many possibilities for moving forward, but necessary to hoarding, pillage, and spoliated objects. So my conclusion is, why bother with art objects and archive restitution? We've heard a little bit from Jamaica why they matter, and they're certainly central to anthropology, museum studies, art historians, and sometimes lawyers who are involved still to this day in ongoing World War II Nazi art looting laws, which have become extremely important to open up these shady networks of art and heritage theft, for example, from Syria and Iraq and during wartime situations. The other reason why objects, why archive restitution, because it's become doable sometimes. The positive news in the past decade is global activism. Changing attitudes have shifted the ways in which European former colonizers who possess the archives and the museums have come to understand where their stuff comes from in colonial contexts and what actually belongs to them. Thank you.
Thank you so much, Susan. You gave us so much food for thought, and unfortunately, we don't have a lot of time to unpack and to talk more about your questions. Very provocative, some of them. But I would like to take a few minutes and give the chance to each and every one of you for some concluding remarks, and perhaps building on a comment that Professor Marius Tabe posted in the chat regarding international organizations and the role of allies. I would like to ask you all, is there a potential for global solidarity when it comes to reparations? And perhaps, Professor Ian Hancock, we can start with you, but please, each of you just take 30 seconds to answer these questions so that we can move on to the next session.
Magda, you say global solidarity. Are you referring to the world as a whole, or global Romani solidarity? Because we are global. We're in all the countries pretty much. And
I'm referring to different moves of movements for reparations. So not only to Roma, but rather between different populations and movements for reparations.
Absolutely, and we need to work in tandem with non-Romani people as well. The problem is that as a diaspora population, we are not properly united in any way. We still lack enough educated people with enough clout to make a mark, to be recognized. So my banner has always been for education, not only of our own people, and if we were to receive any remuneration, I would personally send it towards education. But I also firmly believe that the non-Romani world needs to be educated too about us and to take our situation seriously. We've got the same problems that we've heard about today. Illness, short life expectancy, even starvation in some parts of Europe, and that is a fact. Homeless children, so many problems, and we need to work together with humanitarians, whatever they are, whoever they are.
Thank you very much. Bert, over to you.
Yes, in terms of solidarity, we were very encouraged with the global young people's movement over Europe, in the United States, in the Black Lives Matter movement. We saw that a rope was cast around Colson, who was a former trader of enslaved people, and his statue was torn down. A lot of statues have been taken down for people who were glorified in the past, but were in fact contributors to our enslavement. So I think, and I'm very optimistic, that the movement, which we saw yesterday, last year rather, is going to continue, and we will get solidarity around the issues. We saw where Jesus University in the UK returned an artifact to the Nigerians about 2 months ago. So the movement for return of artifacts is very slow. It's part of the tourism industry in these first world countries and European countries. But I think that the movement is, and young people are leading the way, that reparation will not come off the agenda, and that we will see more and more support for reparatory justice.
Thank you very much. Bridget?
Yeah, I would like to say that the rise of the transitional justice and accountability agenda in the 1990s was premised on not challenging existing hierarchies of power, global power. And I think to move forward for a future for reparations, a future for accountability, we have to rethink the connections between internal power differences and those that impact powerful countries like the US, and not simply those that can be imposed on others. We just had a vote in Congress this week to sell a new weapons system to Saudi Arabia, which will probably use it in its war in Yemen. Alex will speak of other examples that are going on right now in Ethiopia. And we could also speak of other inequalities within our own historical legacies. Until we can develop a stronger and broader groundswell for accountability for historical injustices, I think the international movement will also be limited. These two movements have to be developed together.
Thank you. Alex?
I really just to endorse what Bridget has just said, it is so important to make visible what is invisible, to make those forms of violence and dispossession that are not recognized or are concealed, make them open and make the power relations that underpin these crimes, bring them out into the open. And I think this is the key step towards justice and reparations.
Thank you. And Susan, over to you now.
Well, there's long-standing international laws and courts that have governed spoils of war. But as has been pointed out, the movement has moved, or the needle has moved, towards museums, universities, artists are at the forefront. The United States, in fact, has, and its legal history and its political pressure has been instrumental, beginning with the Nazi looting laws, of extending them and using them and building on them. So the global movement of Black Lives Matter, of decolonizing the museum, and in France, oddly enough, the movie Black Panther, Hollywood Black Panther movement, the Hollywood movie called, I think, Black Panther, something like that, has been extraordinarily influential. Diasporic Africans who are citizens in France have actually done these extraordinary performances where they go into French museums and they seize the objects and they wait to be arrested, which was the opening scene in the Black Panther movement, the Black Panther movie, where they seized an object from the mythical Wakanda. So help has come from the strangest places: US Nazi looting laws and Hollywood movies.
Thank you so much. I'm very grateful to all of you. And now I will pass the virtual mic to Jackie Baba to introduce our next speaker.
Thank you very much, Magda, for a wonderful and very rich panel discussion. So we are very short on time. So without further ado, I'm going to introduce someone who I admire enormously, and I'm sure I speak for all our panelists and audience members too, Albie Sachs, who is a legendary human rights fighter and someone who has dedicated his life very productively to the struggle for human rights in South Africa, but has also been an inspiration, of course, to many of us around the world. I think some of us have had the opportunity of hearing Albie talk on different occasions, and every time you hear him, your heart just rises with the sense of an obligation to do more and to do better. So we could think of no better way of ending our book launch on Human Rights Day than inviting Albie Sachs, former Constitutional Court judge of the South African Supreme Court and one of the chief architects of the post-apartheid South African Constitution, inviting Albie Sachs to just give us a few final reflections. And Albie, thank you so much for joining us. It must be extremely late in South Africa, so we are very, very grateful and honored to have you with us. I don't know if you can turn on your video or whether your internet doesn't enable that, but in any event, the floor is yours.
You can see me, and I hope you can hear me.
Yes to both.
Okay. Well, let me just start off by saying, wow, it's not a great academic term, but it's been, and I am tired because this is my 5th International Human Rights Day presentation, and each one is completely different, but this has been the richest by far. And I was kind of puzzled because you invited me some time ago to contribute to the book, and I sent in a sort of a thought piece, and the next thing I see, it's the introduction to the book. I think it's the first time I've had an introduction to a book that I haven't even read. I didn't even know what the other entries were, but I did have a few ideas, and I wasn't sure when I agreed to take part in the discussion whether or not, having heard the discussion, I could still stand by the ideas, now that they introductions or conclusions to themes that I actually knew not very much about. But I think my 2 main points still are valid, and I'm going to add them. But with the preface of saying, this is such a rich interaction, and it was so lovely to see equal voice being given to people from very diverse backgrounds, some from the communities that have been the subject of the oppression and the violation in the past, continues today, others as scholars interested in the themes from different countries, looking at different continents, different places, but that same central heartbeat, if you like, mind beat and heartbeat. If the mind can beat and the heart can think, the two kind of go together in this situation. It's engaged scholarship at its richest and at most valuable. And it doesn't soften my dilemmas, which I'll come to in a minute. If anything, it increases, intensifies them. But I think dilemma is at the heart of investigation. And I'll explain why I'm saying that. The first is the very concept of reparation. A little bit of research I did reminded me that reparations historically were what the victorious warriors demanded from the defeated people. And after World War II, First World War, which of course wasn't called First World War then, because they didn't know there'd be a Second World War. After that World War, heavy reparations demanded from defeated Germany, and whole factories were moved. Money had to be paid. And that was the understanding of reparations historically in international law for maybe a couple of centuries. Don't take us on again in any war, because if you lose, we're going to grab a lot of stuff from your country as reparations for having had the cheek to either make war against us or defend against us when we attack you. After World War II, because of the Holocaust, partly because of the Cold War and the need for Western Germany to be seen as a bulwark against Soviet expansion and so on, competing with East Germany, the question of some kind of compensation to the survivors of the Holocaust, Jews, emerged, and the term reparation became associated with compensation, money to be paid to victims of atrocious conduct. And it was an absolutely valid and necessary act that was undertaken then. It wasn't profound in Germany itself. In Germany itself, in a sense, the payment was easy. It was the second, third generation of young Germans saying, what were you doing? Where were you? How could this happen? That was profound in terms of changing the mentalities, changing the outlook, and extremely important. It had nothing to do with the payment of lump sums of money to victims, which I totally support, by the way. There's no, that's not problematic at all. But the problem that does emerge is that the dimension of reparations, which has become pronounced and predominant, is the dimension of monetary compensation for criminal, atrocious, violent conduct, misconduct in the past that continues often today. And I feel that, in a sense, the emphasis on money, cash payments, is debilitating a more profound reparations movement. I think early on, one of the speakers said, it's not only money. I would say it's not money. It can include money, but the repair aspect has to be something much more profound. It enables us to conceptualize the reparations theme, not on the analogy of taking somebody to court to get injury for smashing into your motor car or killing the breadwinner of your family. Remove the reparations theme from that form, or the fine that you pay because you've been found guilty in a criminal court, and make it much more profound and much more related to the nature of the injury and the kinds of remedies that could appropriately be found. And I was wondering, why did I feel so strongly about this? There are lots of themes and ideas you feel, yes, no, maybe. Here I feel strongly about it. And it's partly personal. When I was planning to come back to South Africa, having been blown up by a bomb put by apartheid agents in my car, one of my lawyer friends said, great, Albie, now we can sue the bastards. And I felt actually affronted by that. I felt shocked by that. I felt it's commodifying pain and injury. This is my arm, and it was part of me, and it was part of our endeavor. I was a volunteer, we were fighting for freedom, and I'm proud that I was in the struggle and that I survived the struggle. And our reparation came through the Constitution, through transforming our society. And that's what validates for me the endeavor that ended up my losing my arm. It's the restoration of dignity, it's the validation of idealism, it's the hope, it's the acknowledgement of what it was all about coming out in other concrete forms. And in a weird way, the emphasis on compensation, it just occurred to me, thinking what I should say now, would almost be the triumph of neoliberalism. You pay out, you buy out, you've compensated, it's over. Where's the problem? That putting it in an extreme way. And it's also foreclosing other avenues, which we've heard about, restoring the stolen objects, apologies, forms of education and support that could be so rich and valuable. In the South African Truth and Reconciliation process, we had 3 commissions. One was hearing the truth, hearing the stories. Very powerful, very emotional. It was acknowledging the pain, listening to people, and saying to yourself, where was I? What could I have done? I think it was an American political scientist said the purpose of the Truth Commission was to convert knowledge into acknowledgement. Money doesn't convert knowledge into acknowledgement. That's owing a debt. Acknowledgement is phenomenological. It's understanding. It's spiritual. It's imaginary. It's profoundly educational and profoundly meaningful to the people who were victimized. That what they went through and what they're going through is acknowledged by the world. The second part of acknowledgement came from the perpetrators. To get amnesty, they had to acknowledge what they'd done. And it was deeply significant. It doesn't leave room for denialism, because the very perpetrators, sometimes following orders, sometimes giving the orders, came forward and said, I did this. And maybe one of the most powerful moments in the whole process was when one of the persons who'd been tortured said to the torturer, tell me, Sergeant Benzine, how can one human being put a wet bag over the head of another human being and make them suffocate and think they're going to drown? How can one human being do that to another? It was so powerful. And the torturer cried. This man had been all powerful, he wept. Now people remembered because they could identify emotionally with situations like that. Money, in that sense, wasn't involved. The third commission dealt with reparations, and that was the one that had the least impact. The feeling in amongst many people in government is now it's the Mandela government paying out for the crimes committed under apartheid. Under apartheid, the whole nation suffered. Why should 20,000 people get money? But it was done in a callous way. There was delays in the payments. The amounts were never enough. And the people who hadn't had money suddenly get $10,000, $20,000, $30,000. It's spent very, very quickly. And there's a sense of emptiness afterwards. The money wasn't a solace. The money was important for poor people. It is a signifier. I'm not saying it should never be used, but if the emphasis had been more on finding community actions, getting the companies that benefited out of apartheid to contribute something in a meaningful way in their neighborhoods, if communities could have been mobilized. There was one bridge that was built over a railway line. That's what people wanted in honor of a freedom fighter who died under police fire. These things are deeply meaningful. Cash payments, I think, are not the way to go. They can be the way to go. I think the Romani people clearly feel that there's this massive inequality, that Jews got compensation, often quite handsome, and we are decades later still battling. It's a form of non-acceptance of the violations that were done to them. It's not even the money coming through. So I'm not saying money shouldn't be used, but I think in a way it could liberate the reparations movement if it wasn't seen as identified with cash payments, because the cash payments for what was done 200 years ago, 100 years ago, it's going to be difficult to justify. The current community should say, why are we paying now to people who didn't suffer directly themselves what happened a century ago? It's not going to get very far. Whereas if you deal with the continuing themes of marginalization, disregard, disrespect, indignity that continue from those days to the present day, I think that will go much further. It can be statues, it can be restitution of looted property. It can be a whole range of different things, but get people involved. From the benefited community involved in the process themselves, linking up with people from the oppressed community. The very last proposal I'm making, and this is all very much on the wing, themes in my lifetime that have started off with a concept that seemed very remote have begun with the concept. The concept has become a declaration. The declaration has become an international instrument. The international instrument gets absorbed in local law. The environment is one example of that. These crazies who had the idea of greening the world, and it seemed absolutely loopy. But the next thing it's catching on, and now people are rushing to show how green conscious they are. High leaders of major corporations and governments. So I think the reparations theme is somewhere in that conceptual idea. It's powerful, it's strong, it's rooted in real human experience and massive injustice that's palpable and tangible. And it's basically moral, it's basically decent. And maybe one can think in terms of some kind of international declaration on reparations that enlarges the theme, the concept of it, that doesn't simply say, you got to pay us so many millions or billions or trillions or quadrillions for the harm that was done. I hate human endeavor being reduced to a market thing with a dollar sign on it. There's something wrong if that's the way we go, which is not to say dollars don't count or Deutschmarks don't count or pounds don't count or francs don't count. But this is what emerges to me from having listened to this very marvelous and rich discussion that, as I said, have intensified the contradictions in my own head about this whole project and whole process. So thank you to the Harvard group for setting it up, for bringing us all together, for enabling us to hear and learn from each other. And thank you for bringing out the book.
Albie, thank you so much. This was very, very moving, as you always are, and very thought-provoking. And I wish we were at the beginning. I wish we were at 9 o'clock Boston time, not 12:15, but such is life. I think you've raised so many questions. You've, as usual, presented us with a very powerful ethical compass. And I think many of the points you made are extremely relevant to the battles that we're all engaged in today about the kind of relative place of material reparations in the struggle for social justice. So thank you very much, and thank you for your life of struggle on these critical issues. So I want to conclude by saying an enormous thank you to all the participants. I think it has been a very rich discussion. We weren't part of your other events, Albie, so I can't comment on whether we were the best, but I think it was as stimulating and as rich as we could possibly have hoped. I want to thank the audience, some of whom have stuck with us over 3 hours, which is amazing. Nobody likes doing that on Zoom. I want to thank my very dear fellow editors for this journey together. Magda and Carrie, we've learned so much from each other, and we've spent so much time together. It's been wonderful. And I want to finally thank the team at the FXB Center, including in particular Veronica and Megan, our communications colleagues, who've so professionally and seamlessly kind of linked us across the globe. We really hope that everybody will read the book when you finally get it, and we apologize that it's taken so long, and read everybody else's chapters, which you may or may not have had a chance to do, because they really are very rich and very broad ranging, but themes kind of cross-articulate in a beautiful way. And we hope and trust, knowing who all of you are, that you will continue to contribute in whatever way you can to the struggle for social justice, including the struggle for reparations in whatever domain for past state injustice. So I invite Magda and Carrie to kind of like turn on your screen, Magda, just be part of this, and to wish you all a very happy Human Rights Day. And thank you again to all of you. And hopefully we will come together again sometime in person. But very warmest wishes from all of us here in Boston. So take care and thank you. Bye.